this ad hoc committee, through yourselves, made sure that no voice is suppressed, that all who have something to say and who had indicated or requested the opportunity to say it are given an opportunity to do so. Because as I repeatedly said, we are not dealing with a party political project. We are dealing with a South African project. So the outcome of this process must reflect the will of South Africans as a whole. And therefore, I want to say we appreciate also the full participation of all political parties represented in Parliament, and their agreement that those who are not represented in Parliament should also be afforded this opportunity that we are making available today. So without much ado, I also want to say that we are a democratic institutions, and we are diverse culturally, religiously, and otherwise. And therefore, it is natural that we will hold different opinions on different issues, but the difference of our opinions should not mean conflict. We have to exercise extreme political tolerance and not insult one another, because this forum doesn't belong to us, it belongs to the people of South Africa. So any misconduct on this forum will be actually offensive to the people of South Africa, black and white, who elected us to come and represent them in this parliament. I thank you for your continued discipline, tolerance, and support for this process. Thank you very much. And I'm also particularly happy that the religious sector, notably the South African Catholic Bishops' Conference, are here because, as you know, the missionaries were the first to arrive even before the colonizers, so they know the story of the land question and disposition quite well, and I think they have the best records of what happened since even before colonization. So we appreciate their participation in this matter. But also, I think we should appreciate the fact that the National House of Traditional Leaders are here because as we heard from Kosato yesterday, that there was dispossession of land without compensation, and why should we compensate now? And as the committee, we cannot speak on behalf of anyone. We are happy that everybody are here to speak for themselves, and as the committee, we will have an opportunity to engage with all the contributions on their merits and demerits. But for today, as agreed by yourselves, honorable members, I will give every presenter or submitter 15 minutes to speak, and the other 15 minutes will be used by the honorable members to ask questions of clarity, not to discuss the merits and demerits of the contribution, because that will be done by the committee on its own. Today, it's not for the committee to deal with the merits and demerits of contributions, but to ask questions for clarity. And having said that, honorable members, and believing that this approach still enjoys your support, we will request the presenter from SABC to take the floor and request that the presenter must introduce themselves and their positions in their organizations. Thank you.
Chairperson?
Yes.
Yes. This meeting is live on TV, so members and speakers are requested to switch on their videos when they speak.
Can you raise your voice?
No, I was saying that the meeting is live on TV.
Yes.
So members and speaker and our presenters are requested to switch their videos on when they speak.
Well, thank you very much. I see the public is overseeing what we are doing. That's why we are live on TV. So we have to create, conduct us the proceedings with the necessary good decorum. Thank you very much. The representative of the SABC.
Good morning, Chairperson, and thank you for this opportunity. My name is Mike Pothia. I work for the Catholic Parliamentary Office, which is a unit of the Southern African Catholic Bishops' Conference. I'm not a bishop, I'm not a priest, I'm a lawyer. But I've been working in this capacity for the Church for quite some years, and we've had the pleasure and the privilege of making many submissions to Parliament on a variety of pieces of legislation, including previous constitutional amendments around floor crossing and similar things many years ago. I want to say at the outset, Chairperson and members of the committee, and I've put it in our written submission, that we don't take a position in a sort of simplistic way saying, yes, we are in favor of expropriation of land without compensation. Neither do we take a position that says we are against it. The matter is far too complex and nuanced, in our opinion, certainly for a religious organization to take that kind of very, very firm stand. And of course, we are not a political body, we are not ideologically driven. We seek to understand this question primarily from the point of view of how it would benefit or indeed harm the common good of our country as a whole, and in particular, the dispossessed and the marginalized and the people who have in the past obviously suffered from the loss of their land and access to land. Our submission really is very, very simple in terms of its sort of legal content. The first point that we want to make is that we would like to support very strongly the clause that reads that a court may determine the amount of compensation to be nil. There's obviously an enormous amount of anxiety about this constitutional amendment and about the legislation that may flow from it. Some of that anxiety perhaps is not warranted. On the other hand, we shouldn't pretend that empowering the expropriation of land in this way is a minor matter. It obviously has all sorts of ramifications, and those have been discussed at great length in this committee and in public debate for a long time. So the intervention or the role given to the court here is of the greatest importance. We have confidence in our courts, in our legal system, and people should take great comfort from the fact that the determination of nil compensation is something that has to go through the court process. Unless, of course, there's agreement between the parties, which on the surface would seem to be unlikely. But nevertheless, the fact that it's going to go before a court and that people will have the opportunity to have their say and to bring argument before a court, in other words, an independent body, is of the greatest importance. If this had been merely an administrative matter where a government department could make a decision, then we would have found ourselves unable to support that particular way of going about things. The wording that says may determine is also very important because that clearly gives the court a wide discretion in the matter. So that really is the first point that we want to make. We strongly support the fact that this is, if you like, a court-driven or at least a court-approved process. Our second point is something that we are a little bit more concerned about, and it's not something that we feel that we can support in the way that it stands, and that is the idea that land and any improvements thereon should be expropriated without compensation. This seems to be a departure from the generally understood position, which is that we were talking about land expropriation, and indeed talking about redressing past injustices where the land was taken. When you bring in improvements, you complicate the whole matter, because as we know, in many cases, unimproved land was taken, large quantities of it. And over the years, the people who got that land spent their money, borrowed money from banks, etc., to build improvements. There doesn't seem to be the same moral force behind taking the improvements without compensation as there clearly is in taking the land without compensation. And this is again something which could potentially complicate the whole business and make it even more controversial than it already is. So from our perspective, perhaps there needs to be a separation between the expropriation of land, unimproved land, without compensation, or where the land has been improved, that there should be compensation offered or negotiated to cover the improvements. Now, of course, if it is said that this is intended for situations where land plus improvements were taken under the apartheid system, black spot removals and things like that, then fine. Certainly, of course, if people's improvements were stolen from them, those who now benefit from the improvements have no right to compensation for them. But I think the members of the committee will see that there will be all sorts of arguments about when the improvements were brought about and who paid for them and what they are worth now and so on. So to us, this perhaps just muddies the waters a little bit. As I say, it detracts from the clarity, the moral and ethical clarity that attaches to land expropriation without compensation in certain circumstances. And we'd like to see that the two matters, the land and the improvements, dealt with somehow separately, or at least with different criteria being applied. It may also be argued that in our legal system, improvements attached to the land, and one cannot be bought independent or sold or alienated independent of the other. That is really just a property valuation challenge, which is not a particularly difficult one. Any property economist can determine what the value of a piece of land is, regardless of what improvements are on it or not. So there's no difficulty in making that separation between the land and the improvements. Chairperson, really, we have nothing more to say about the actual clauses of this very short piece of legislation. Short, but clearly of great significance to our whole country. But I would like to just introduce the expropriation bill that is currently before Parliament, because if we understand correctly, the expropriation bill, once it becomes an act, will be the main piece of legislation, if not the only piece of legislation, under which, or in terms of which, expropriation without compensation will take place. And as you know, the expropriation bill sets out 5 criteria, 5 circumstances, if you like, under which expropriation without compensation can happen. So these things are intertwined. This constitutional amendment and this piece of ordinary legislation, the expropriation bill, are very closely intertwined. And I think it's necessary to take cognizance of both of them. And in that respect, one notices that the nil compensation circumstances named in the Expropriation Act are somewhat different from simply the idea that land can be taken without compensation as historical redress for when it was taken in the past. And I'm not sure how that gets resolved. I'm not sure whether this committee has any jurisdiction to look at the expropriation bill and the circumstances mentioned there. But it does seem to me that it would be a pity, on the one hand, for that bill to go sailing through Parliament, not specifically listing land reform as one of the grounds for expropriation without compensation or for nil compensation, while this constitutional amendment goes through on the back of that ground of historical redress. And again, if the intention is that at a later stage, ordinary legislation other than the expropriation bill will be introduced to give effect to this constitutional amendment, then the task will be to make sure that that ordinary legislation dovetails well with the expropriation bill. So simply because that bill is itself going through Parliament at the moment, and we would expect public hearings on that one to happen in the near future, hopefully. It's just a plea, if you like, from us that these two things be somehow, as I say, made to correspond well with each other. Chairperson, to reiterate, we don't want anyone to be saying, oh, the Catholic Church said they're in favor of expropriation without compensation. Neither do we want anyone to say that the Catholic Church has come out against it. We think that these things have to be dealt with on the proverbial case-by-case basis. Each claim or each proposal to expropriate land without compensation is going to have to be carefully adjudicated. But the principle that there will be circumstances, given our country's history, where expropriation without compensation is the appropriate way to go, is a principle that the Catholic Church supports and upholds. That's all we have to say, Chairperson. We wish you well with your deliberations.
We'll open the floor for questions of clarity, not debate. But I just want to say from myself that I expected that you would also deal with the question of the land owned by the church, because when land was taken away from indigenous populations, much of it was given to the church societies, the Catholics, the Anglicans, the Lutherans, and so on. And I guess that churches have played an important role and still play an important role in our community. What do you have any ideas as to this matter can be addressed without forcing the government to expropriate land in the hands of the church? I know that there are lots of farms owned by the churches which are not utilized and so on. Do you have any thoughts on that?
Yes, Chairperson. Historically, yes, you're quite correct. Of course, a lot of land was given by whatever the authorities were to the churches. Sometimes those were indeed traditional or indigenous authorities, and sometimes they were the colonial authorities. As far as the Catholic Church is concerned, we are no longer in the position where we have many of these large tracts of land, church farms and large rural institutions, etc. There are a few left. I don't have exact numbers. As you know, in the Catholic Church, certain things are owned by the diocese in the name of a bishop of a particular geographical area, and other facilities and entities are owned by what we call the religious congregations, like the Marian Hill missionaries in KwaZulu-Natal, for example, and all sorts of others, the Dominican sisters, etc., etc. It's difficult actually to get a handle easily on church land ownership. But I do know that over the years, especially probably the last 30 to 40 years, many, if not most, of those church farms and rural institutions owned and operated by the church have been alienated. In some cases to local communities, in some cases perhaps to other churches or organizations. I know that there have been some processes. I'm thinking particularly of the Northern Cape in the area around Springbok and those towns where the church did own significant land holdings. There was a negotiation process with local communities and local community structures, which resulted in a very voluntary and constructive handing over of farms and other land holdings. Can it be addressed without force? I have no doubt that it can be. The church is certainly ready to negotiate these things and to hear from the government if particular parcels of land would be earmarked for expropriation. We would certainly be open to talking about it. And of course, then the normal historical research and so on would have to take place. How did the land come into the possession of the church? What were the original conditions? What is it being used for? Etc., etc. But in principle, the church is certainly willing to engage with the authorities on this question. I just want to reiterate the idea that the Catholic Church, and as far as I know, any other church, is, as some people have said in the past, the churches are some of the country's largest landholders. That is simply no longer true. It may have been at one stage, but it is certainly not true anymore. We're not a significant landholder. If you counted up all the land upon which ordinary churches stand, Catholic schools, Catholic hospitals, and so on, yeah, it's a significant amount of land. But in terms of particularly the rural holdings and what we would think of as land that might be nominated for expropriation without compensation, it would be very small amounts indeed.
Thank you for very constructive response. Honorable members, may I open the floor to yourselves? Advocate Ramanu, can you help me with the hands, please? Can you help me with the hands, please?
Chair,
okay, Ramanu. Yes.
Chair, yes, I see the hand of Dr. Lozi.
Doctor?
Lozi and Mr. Gumede.
Lozi, yes, the Honorable Gumede. Okay, Honorable Dr. Ndlozi, proceed.
Thanks kindly, Honorable Chairperson. Well, I'm much more interested in clarifying the last submission by the church. Just before you asked the question regarding the church's own land. So the presenter said that the Catholic Church should not be seen to be saying whether it supports expropriation without compensation or it doesn't. And that seems to be the crux of the presentation or the submission of the Catholic Church. I wonder if I could clarify what causes this ambiguity, and seeing that there is an acknowledgement that this particular initiative of amending the Constitution, it doesn't come out of some uncontrollable desire for state power and just taking people's properties. It comes out of an acknowledged crime against humanity, which missionaries were complicit in. Missionaries were involved in the colonial massacre and murder and dispossession. How could you be ambiguous? How could your submission arrive at an ambiguity of not saying we support expropriation of land without compensation used as a mechanism to address a historic injustice out of which a crime against humanity was formed, but also in which missionaries were complicit in? That is my clarity. I find it hard that the church would come here with an ambiguous position on a question of a crime against humanity as colonization and apartheid. The church should have atoned by now. It should be unambiguous. It should not stand on the fence. That's worse coming from the church, to stand on a fence when you are supposed to resolve peacefully through legislative means to avoid instability in land struggles to have everybody live in dignity. How can the church come here and be ambiguous? I find it very bizarre. Thank you very much.
Chairperson, would you like me to respond first to that question?
I think Honorable Gumede should ask a question and then you can respond to both of them.
Yeah.
Chair, in the absence of the chair, I'm not sure whether should I proceed or wait for him to give me the mandate to do so. But I hope he will hear us or hear me when I speak. Morning, colleagues. Morning to the chair, and morning, Mike. There is just one question that I would love that you comment on. We appreciate that you support the court involvement in the process. But what will be your take?
Ramano, I think you must call the chairperson privately because I don't think he's aware he has missed his responsibilities here. And the void he's creating is really not good.
I will do so.
Honorable members, can I make a suggestion?
I would suggest that you continue.
Yes. I was going to make a suggestion that maybe we allow Honorable Lusoma to chair whilst the chair is.
Hello, honorable members. I'm here.
Oh, thanks, Chair. All right.
I'm here. I actually had everything that was happening. I just had a problem with my gadgets. Who else? Which other hands do we have?
You had Gumede. I have not finished my comment.
Proceed, Honorable Gumede.
Yes. What I was saying that I appreciate that they do support the involvement of the court or the role that the court will play or is going to play. But I wanted Mike to comment on the side of appeals that may appear endless, especially the courts being used by those people who are in fact against the process that is taking. Would he favor a situation that so many people then queue at the courts to challenge the processes or the decision that would have been taken politically? Thank you, Chair.
Any other hand? Advocate Romano?
Chairperson, that was the last one.
Yes. Mr. Mike, before you answer, can you also just address this question raised by Honorable Dr. Ndosi about crimes against humanity? You'll remember that apartheid was declared a crime against humanity by the international community. And I think that's where there's a convergence between the church and the international community and the indigenous people. on that question. If you could address that question as well, and this question of the courts that Honorable Gumede has eloquently raised.
Chairperson? Chair?
Yes.
No, I just received a message from Parliament. They are appealing to members to switch on their videos when they speak.
Oh, okay.
Yours is off.
Is mine on?
It is off.
You know, my gadget doesn't respond. I don't know, but I'll keep on trying to sort it out. Let's proceed.
Thank you, Chairperson. Honourable Ndlozi's question or statement, I don't think that our position is an ambiguous position. It's not that we don't care one way or the other. What we're trying to avoid is what I would think of as a simplistic approach for an institution to come and say, yes, we're in favor of expropriation without compensation, full stop, or no, we're against it, full stop. To us, that amounts to basically sloganeering, and that's not what we're interested in doing. As I said, there will be cases where the argument in favor of expropriation without compensation will be very clear and very persuasive, and hopefully persuasive to everybody. There will be other circumstances where it's going to need much more negotiation, where the circumstances may be not as obvious and as clear. Another point to make in this regard is that if it could be shown that simply by expropriating without compensation a certain amount of land in this country and handing it over to a certain number of people, that we would thereby undo or resolve the great historical injustices that we all are aware of, well, then that might be a very good argument for much broader support for the project. But that has certainly not been shown. The mere fact that a piece of land is taken from someone, whoever they may be, without compensation, doesn't in any way at all guarantee that it's going to be used to the benefit of anybody else. And unfortunately, the history of our land reform since 1994 tends to show that there has been very little successful land reform. In our submission, that's not because of the willing buyer, willing seller policy. It's not because compensation has had to be paid. There's been plenty of money paid out for land. There's plenty of money available to pay for land. It's the lack of support afterwards. It's the lack of proper planning, etc., etc. So I would respectfully say to Honourable Ndlozi, we are not ambiguous about this, but we're also not just going to come down on one side or other of the argument simply as a matter of ideology or of putting out a slogan there. Missionaries involved in massacre and murder, that may be, I suppose, overstating it a little bit. But yes, of course, the church does bear responsibility for the role that it played in the whole colonial project. That's clear. And the Catholic Church, along with a number of other denominations, appeared before the Truth and Reconciliation Commission back in the late 1990s and made a submission in which it did take responsibility and made admissions about the role that it had played, and asked indeed for forgiveness for its failings historically. And when I say historically, I don't mean hundreds of years ago, but up until the very recent past in these matters. We're very much aware of that kind of history. We have tried to find ways over the years of contributing to the undoing of that kind of history. Sometimes, as I mentioned, by either giving away or returning one way or the other land to communities. And we would be open to continuing to do that. But we are not going to simply come down, as I say, in a simplistic way on one side or another of what is a relatively complex and controversial and contested debate on this particular topic. Honourable Gumede's question around the court process and the appeals and the delays that would flow from that. Yeah, I think we all know that our court processes, unfortunately, are rather slow. But I think it would be worse if the courts were excluded from the process from the beginning, because then you would have administrative decisions being taken. And those who were unhappy with those decisions would then be rushing off to court to take those decisions on review. And if they lost the review, they'd be wanting to appeal against that loss. So all it would do probably would be to add yet another level or layer of decision-making and potential delay to the whole process. If a court is involved from the beginning in the determination of compensation or the sanctioning of nil compensation, I suggest that's actually a shortcut in the process rather than a lengthening of the process. Chairperson, your question around the crimes against humanity, I think I've tried to answer that already in my answer to Honorable Ndlozi's question. But as I say, yes, we are perfectly willing to admit the role that the Catholic Church played in the crimes against humanity that were constituted by the colonial project and by the apartheid project. Of course, we would also point to our opposition, particularly in the apartheid years, and to the role that many church people and church institutions played in that respect. But we have no wish to pretend that the Catholic Church was not complicit in what happened in those years, and we are always ready to do what we can to make up for it if possible.
Thank you very much, Advocate Bonani. Are there any other hands? Honorable Ndlozi, Dr. Ndlozi, is that an old hand or a new hand?
It is a new hand.
Okay.
It's a hand that is born again.
Okay, we allow the born agains proceed.
Thank you very much, Honorable Chairperson. It's a very short a thing I'd like the reaction of the church on. I find it strange, again, that the presenter says the process of expropriation of land without compensation to address the historic injustice is sloganeering. I wonder if that does not come close to a deliberate misinterpretation or even patronizing attitude on the entire process. You see, the church was not ambiguous during colonization. It never said it won't take sides. It took the side, and it didn't take the side of the victims. It took the side of the conquerors. You have an opportunity now to take a side. We are trying to correct. I don't know what we need to show. That land was taken. That is what colonial dispossession means. African people were dispossessed of their land and the dignity to call South Africa their home. You do not return the land, you have not resolved a historic injustice to African people. That's what we are busy with here. It's not a slogan. So how can the church come here and say it cannot take sides? How can you stand at the TRC, say you apologize, you must be forgiving? 25 years later, you are back here when we are trying to correct that which you are apologizing for, and you are saying was sloganeering. Why are you not taking sides? The sides are the victims of a colonial crime against humanity, in which the mechanism we are trying to approve, we have not yet arrived at the bill that is going to work out the mechanisms. We're establishing a principle that for this historic injustice, everybody must be prepared to let go of the land without compensation for the purposes of this particular historic injustice. I find it strange, of all the presentations that we're going to receive, that the church, in the name of God, cannot take a side on this issue. I find it really strange. Thank you.
Honorable Member Mike, I guess you'll agree that that's just a request for clarification why we are not taking sides. We are not entering into a debate. It's just a request for clarification why. And I see Honorable Shibambo's hand is up. Can we hear Honorable before?
No, my hand is not
Honorable
up.
Shibambo?
No, my hand is not
it's only
up.
on the picture.
Yeah. Oh, yes, it's just on the picture, yeah. But
yeah.
otherwise, it's not up.
Yeah.
When I appear, yeah. I'm not raising it yet, yes.
Thank you very much, yes. Mr. Mike, that we can proceed.
Thank you, Chairperson. The Church does take sides. I think I made it fairly clear at the beginning that we approach this question from the perspective of justice, historical redress, and also the common good of the country as a whole today, which is obviously also an important consideration. In principle, and I'm not saying this with regard necessarily to land expropriation, with or without compensation, but in principle, it is always possible that in one's attempts to undo a historic injustice, one can end up doing more harm than good. I think we're all aware of instances where that can happen. And I repeat, I'm not saying that necessarily is the case with land expropriation. In certain circumstances, it might be. In certain circumstances, it won't be. And that is why from the beginning, we've tried to say, we're not going to come down, if you like, and take a simplistic side and say, yes, we must have widespread land expropriation without compensation. That is the only way forward for the land question. That is the only way to redress historical injustices. And neither are we going to say that expropriation without compensation is always wrong, that it is theft, that it's going to destroy the economy, etc. We're not going to say that either. That's what I mean by sloganeering. This whole debate has been attended by so much sloganeering from those in favor and those against. We are hoping for not an ambiguous position, Chairperson, a more nuanced position so that we can make some real progress as a country on this question. That's the position of the Church.
Thank you very much. I think the committee will deliberate on your submission. That was just a question of clarity. I think we have done your best to clarify. Is there any other hand, Advocate Romano?
There's no
Advocate Romano? No other hand.
There's no hand. You can proceed.
Yeah, let's proceed to, it's Agri what? The second one?
No, it's AfriForum.
AfriForum. Yes. AfriForum, the platform is yours.
Thank you, Chairperson. Frantz Fanon, the author of The Wretched of the Earth, was right about more than what many people of European descent would like to admit. He was right about the psychological impact of liberal Enlightenment thinking on the colonized. He was also right about the consequences of the superiority complex that goes with it, and more particularly, the imperialistic attempts by some to change the world to suit their preconceived ideas about how the world should operate, by destroying the identities and cultures of others. It has been 31 years since the laws according to which the apartheid system was governed have been rescinded. And by now, almost everyone has become disillusioned. Minorities are disillusioned by the fact that their rights aren't protected to the extent that they've been promised. On the other hand, millions in various African cultural communities have been disillusioned by the fact that their hopes and dreams have not materialized. This begs the question, are we really free? Can we really say that South Africa is a free country when it suffers under an unemployment rate of more than 32%? In other words, can we say that simply giving people the right to vote is sufficient to make them free? I'm sure that most of the people in this discussion would agree that the answer is no. We are free to vote for some political party, but in the real world, we aren't free. This is what the author of The Origins of Totalitarianism, Hannah Arendt, meant when she spoke of the freedom to be free. To be free is not merely to comply with some revolutionary prerequisite of freedom, but to actually experience freedom. So in this context, it's good to have discussions about land reform and property rights. The problem, however, with the South African government's approach to land reform, its demand for expropriation without compensation, and the bill that is currently under discussion, is that it will achieve the exact opposite of that which it proclaims. Expropriation without compensation will not promote freedom. Expropriation without compensation will not promote justice. It will not promote equality, nor will it lead to increased job creation. It will do the opposite. It will curtail freedom, it will curtail justice, and it will increase unemployment. What this country needs, Mr. Chairperson, and what those who claim to represent the people in particular need, is a serious injection of empiricism. And what I mean when I say we need more empiricism is that we need to be more empirical, that our policies and our actions must be guided by what we learn from and what we experience in the real world, not by some cargo cult or a set of utopian ideas that are completely detached from reality. And if we were to talk about an issue such as land reform and expropriation without compensation, and we were guided by empirical evidence, we would have to consider the following.
Yes,
that the South African government has by now spent probably more than 60 billion rand on land reform, but of all the land acquired by the state since 1994, only 6.3% has been transferred to private ownership. That about a quarter of the land in South Africa is by now state-owned or state-controlled. That the so-called hunger for land is largely a myth, particularly when we talk about agricultural land. More than 90% of land claimants have said that they would rather want money than land. About 60% of land claims are in urban areas. 84% of land grabs are in metros. Only 2.8% of university students are enrolled to study agricultural science or similar courses. Only 1%, that's 1 out of 100 people in South Africa, believe that more land reform would improve their lives. And 0.6%, that's virtually 1 out of 200 people in South Africa, think that land distribution is South Africa's most serious unresolved problem. The Department of Agriculture has stated that more than 90% of land reform projects have failed, with commercial farms transformed into subsistence farms or squatter camps. Former President Kgalema Motlanthe pointed to large-scale corruption as one of the most significant contributing factors to the failure of land reform. We would have to look at the majestic failures of similar policies to those that South Africa is flirting with, which have already been tried and tested in communist China, the Soviet Union, Venezuela, and Zimbabwe. Nowhere have these state-driven socialistic redistribution policies resulted in a heightened sense of freedom and justice, and nowhere has it sustainably increased employment. Henry Hazlitt said that the art of economics can be summed up in one lesson. The one lesson is the following. The art of economics consists in looking not merely at the immediate, but the longer effects of any act or policy. It consists in tracing the consequences of that policy, not merely for one group, but for all groups. Murray Rothbard said that it is no crime to be ignorant of economics, but it is totally irresponsible to have a loud and vociferous opinion on economic subjects while remaining in this state of ignorance. All the evidence indicates that this policy doesn't work, and that a transformation of the current half-baked socialist policy into a fully fledged socialist policy would simply transform the consequences thereof from a half-baked failure to a fully fledged failure. Reflecting on the atrocities of the 20th century and the lessons learned from it, Hannah Arendt said that we are inclined to believe that freedom begins where politics ends, because we have seen that freedom disappeared where politics became endless and limitless. The less politics, so it seems, the more freedom. Or the smaller the space occupied by the political, the larger the domain left to freedom. To truly liberate people from the wretchedness that Frans Fanon spoke of, they need to be freed to be free. This can only be achieved through empirical policies that are grounded in facts and evidence, not through some flight of fantasy with utopian ideas that are detached from reality, as this would only heighten the sense of wretchedness among the people in South Africa. Thank you, Mr. Chairperson.
Thank you very much. May I, just before I open the floor, say that the Freedom Charter said that the people of South Africa as a whole are entitled to the right to determine their own destiny. And that in the Harare Declaration, the South African people, with the backing of the AU, develop a process for addressing their own issues without foreign intervention. Do you believe in the capacity of South Africans, both black and white, to find solutions to their own problems? And if so, can you explain why you rushed to the United Nations to raise your concerns about processes in the country before South Africans themselves sit as we are sitting now to deal with these issues. Thank you. I'll take other hands and then you can answer this together with the other questions. On Advocate Bonani.
Chair, we've got Dr. Ndlozi and Mr. Muratel.
Dr. Ndlozi, Honorable Muratel. Honorable Dr. Ndlozi, proceed, please.
Thanks, Honorable Chairperson. I'm fascinated by AfriForum's reliance on Frantz Fanon and Hannah Arendt. So I've got few clarity-seeking questions. The first one, of course, is where did Fanon say or speak about the superiority complex of the colonized? And I'm quoting you directly here. In which book, where did Fanon say that the colonized have a superiority complex? That's the first one. Then the second one, are you aware that in The Wretched of the Earth, actually Fanon centers the question of the land. And he actually advocates that, if possible, the colonized must fight violently to recover their land, that decolonization is unnegotiably the return of the land to the natives. I mean, if you really believe in Fanon, you seem to be doing so, unless it's a dishonest and patronizing reference to Fanon. If you do a rendering Fanon in that way, particularly The Wretched of the Earth, Fanon actually advocates for a violent return of the land. If we are to follow his method, we must violently, if needs be, take back the land. And he's uncompromising that that land belongs to African people. Are you aware of that? And what's your reaction, since you rely on him? And finally, it's Hannah Arendt. In The Origins of Totalitarianism, a chapter on race and bureaucracy, Hannah Arendt says that the absolute dependence on the work of others and the complete contempt for labor and productivity in any form is what transformed the Dutchmen into Boers and gave the Dutchmen and the Boers their distinct concept of race, or that gave their concept of race a distinct economic meaning. So their entire economic philosophy that transformed them into Boers was absolute dependence on the work of natives, contempt for labor and productivity in any form. So Hannah Arendt's take on the historic development of the Boers lies in that particular fact in The Origins of Totalitarianism. Are you aware of that, since you are relying on her concept of freedom? If she were to be asked today, which she clarifies how race and bureaucracy came to characterize apartheid in The Origins of Totalitarianism, she would tell you in no equivocal terms, you have to return the land to African people. Return it without, not buy it, not pay for it, return it, because it was constituted or taken through an authoritarian system which he characterizes as a crime against humanity. Those are my three questions. Thank you.
Thank you, Dr. Honorable Ndlozi. Honorable Rwasata.
Prof and Chairperson, to this all-important portfolio committee, thank you for this opportunity. Lest I fall into yesterday's trap. By the by, what is the name of the presenter? On behalf of
you are helping me as well. I didn't get his name. Mr. Ma, can you give us your name?
For record purposes.
It's Ernst Roots from AfriForum.
Ernst,
ERNST.
or Arendt's surname?
Roots, R-O-E-T-S.
Roots. And then what is your position in the AfriForum?
I'm head of policy and action at AfriForum.
Okay, thank you very much. Honorable Mufrasta, thank you for
thank you very much, Chair.
Thank you very much, Prof. And thank you very much, Mr. Roots. I think the presenter, Prof. and Chairperson, has educated us on a number of things. But however, because he showed how unemployment has been caused and it will be worsened by the process that we have initiated. However, I've got these two questions. Question number one, does Mr. Rich agree that this land we are talking about was illegally taken away from the indigenous and African people as we are speaking now? Is he in agreement with that? I mean, we must start at the beginning. Does he agree that the land was illegally taken from its rightful owners? And suppose he agrees with me. And if he doesn't agree, because I don't see any other option, if he doesn't agree, he will say so. If he agrees with me, how, according to him, are we supposed to address the problem where the land was illegally taken from its rightful owner? Because it would mean, if it was illegally taken, we are sitting with a problem. Is he having any mechanism or proposals which can address this so that the indigenous owners must be the beneficiary of that which was taken away from them? Simple and straightforward as that. We understand all these politics of saying we have got more than 30 years, there is corruption and it will cause unemployment. But can that which belongs to Caesar be taken back to Caesar? And can he come up with the mechanisms of addressing the problem? Thank you very much, Prof.
Thank you, Honorable Murasa, for a pointed question. Is there any other hand? Advocate Ramano?
None, Chair.
Mr. Roots?
I'm willing to.
Hello?
I'm willing to.
You are willing to speak, Honorable Gumede?
Yes, yes, Chair.
No, you are always welcome. Please proceed.
No, Chair, it's because, I had taken a decision that I won't ask Ernst Roots a question. I want to say I'm really, really disappointed. Very much disappointed. It looks as if he is turning history around.
On a point of order, Chairperson.
Point of order, let's hear.
Yes, Honourable Gumede is very much well aware that he's supposed to ask questions of information in terms of the presentation. We are not interested in his view on history at this moment. Thank you, sir.
Honorable.
No, me, I'm very interested, Chairperson. I'm interested in Gumede's view of history if it foregrounds his question.
In your view, Mr. Ndlozi, we're not interested.
Yeah, I'm also important. My view is important. I think you must shut up, man. Let people speak here. Nobody interrupts him, Chairperson. He must shut up.
No, there's only one chair who will make rulings on point of orders. Honorable Dr. Melda, we have different ways of approaching situations. And I think Honorable Gumede is entitled to his way, provided he bears in mind, and I have no doubt that he will do, that we are asking questions for clarity and not debating. But otherwise, his approach is perfectly in order. Proceed, Honorable Gumede.
Chair, I think that's the way, even when the presenter started, he was presenting his views. So I think I'm entitled to put down my views as well. But it's a preamble. That's why I'm saying that he is turning the history around. I don't believe that there is no hunger for land. All what we are saying is just a myth. That's what we have been told here. That we seem to be saying, let's take land back to people. It's just a myth. That we are spending this valuable time for us, we are just chasing shadows, and that's a myth. And he quotes, these are statistics coming from, I think they were done, this 1% thing, that only 1% of people think that the acquisition of land will improve their life. That was a very distorted question that was put to these people, as well as the idea that many people, they go around and invade build shacks around metros. That's a misconception. People are all over. They want land. It's only that they are killed. You go
Honorable Gumede?
Yes, Chair.
Yeah, proceed.
Yes. Chair, what I wanted to find out from the gentleman is, does he really believe that land, historical, I'm talking history now, that land was taken away from Black people? Does he believe that? Because when you come and you distort questions to people, ask them, and then you come with a notion that it's 1%, who designated those questions? And how well were those questions raised? Perhaps, Chair, I support the view that may say, as much as it's not a good thing, that's what the involvement of Parliament is trying to fight a comment by MP Ndlozi that we need to fight violently to get back our land. That's what we are trying to avoid. Otherwise, people are prepared to do that. Chair, let me wait there. Okay, thank you.
Honorable Roots, please address us. Maybe in addition to the illegal disposition of land, we can also address the fact that in most cases, that disposition was violent. And what we are trying to do in this process is to avoid violent resolution of conflicts amongst ourselves. Thank you. Proceed.
Thank you, Mr. Chairperson. Just on a side note, you can just call me Ernst or Roots or Mr. Roots. You don't need to call me honorable. I'm not a member of parliament. So I wrote down the questions, and I'll start with yours, where you asked if I or we at AfriForum have confidence in South Africans to resolve issues like these. And yes, we do. We certainly do have confidence in the people of South Africa to resolve issues like these. But what we do not have confidence in is the people who represent the people of South Africa in Parliament. There was a study done. It might have been the Institute for Justice and Reconciliation. I'm not sure. We can look that up easily. They did a poll where they asked politicians. They surveyed politicians, and they asked them what are their top priorities. And it turns out that education was, for example, number 16 on average. So basically, if you interview people in South Africa and you ask them what are the biggest problems that need to be resolved, and you take that list and you flip it upside down, then you find the list of priorities by most of the people who are sitting in Parliament. So we don't have confidence in Parliament to resolve these issues, but we do have confidence in the people to resolve these issues. But the problem is the people aren't properly represented in Parliament. As far as the question of Mr. Ndlozi, I think I wrote down all three questions. The first is, you might have misheard me. I didn't say that Frans Fanon said that the colonized have a superiority complex. I said that Frans Fanon was right about the consequences of the superiority complex that goes with the liberal Enlightenment thinking. In other words, the superiority complex of those who are doing the colonizing. He was right about pointing out to that. It was a reality, and it's something that we should concede. I do, however, think his reading of Hannah Arendt is wrong, because Hannah Arendt, her entire claim was about, or mission was about taking a stance against totalitarianism. She was certainly not, and would not have been in favor of replacing one totalitarianist system with another totalitarianist system. And she spoke about dependence, and I think Mr. Ndlozi referred to, or Dr. Ndlozi, about Afrikaners being dependent on natives. And I agree. I think that's the words he used, at least. I agree with him. I think it was as an Afrikaner, I think that was one of the mistakes that Afrikaners made in history, was to make themselves dependent on others, and to make themselves dependent on labor from other African or Black African peoples, for example. But what's happening here, what this policy is doing, is to make people dependent on government. So if the whole point is to combat dependency, then we should abandon these policies, because, as I've pointed out, the whole mission here, and I know the EFF, for example, and many in the ANC have said so in the past, is that the state must own the land. So what's happening is people are becoming dependent on the state. So if the mission, or if the point is to increase independence, then we shouldn't embark on policies that will increase dependence. If we're talking about returning the land to the people, this policy is not about returning the land to the people. This is about the state acquiring the land. We know that we know that from what many people have said about this policy, what they aim to achieve by this policy, and we know this from empirical evidence. The fact that only 6% of government acquired land has been transferred into private ownership. So the whole point is, if the point is to give the people the land, to increase private property, then that's something that we can support. But if the point is for the state to own the land, in other words, for the people not to own the land, then that's something that has to be opposed. Mr. Muratshela Setla, I think, if I wrote down his name correctly, he asked, his question, Mr. Gumere's question was actually exactly the same. It was, do we agree that land was illegally taken from indigenous people? And then on top of that, how are we supposed to address this issue? If the answer is yes. The answer to the first question is both yes and no. We must be very cautious of succumbing to this one-dimensional narrative about history, where it's a story that you can tell in 2 sentences and then make certain government policies based on that conclusion. The truth is that there were atrocious instances, and there were massive injustices in this country where land was taken from people in ways that cannot be justified in any sustainable way. And there were cases where people bought land. There were cases where people owned land and they sold that land. And now you cannot accuse someone who bought property from someone of being an illegitimate owner of that land. That's part of the problem with this entire process. And the fact that this comes out so easily, that this intermingling of the idea that land that was dispossessed, or people who were dispossessed, have to be given back their land, with the idea that if you are white and you own land, then by definition you are an illegitimate owner of that land. The fact that these two get intertwined so easily by the people who are pushing this policy is exactly the reason why this is such a destructive policy, because that means it's not about correcting historical injustices. It's about giving the state more power, and it's about pushing an underlying racial agenda. Thank you, Mr. Chair.
Thank you, Mr. Roots. Let me also just remind you that AfriForum members participated in our public hearings, and we appreciate the fact that you attended this hearing, because we want to hear all South Africans, and we will consider their contributions on their merits and demerits. Thank you very much. Can we then give the platform? Yes.
Apologies, Chair. Yeah. Is it possible that we can take a follow-up on the responses of Mr. Root?
By all means. Thank you. Proceed.
Thank you very much, Chair. In the first letter response by Mr. Root, he indicates that the people of South Africa are not well represented in Parliament. Therefore, this process in his insinuation is not a proper process. So my question to him is, why are you participating in a process that you do not believe in? Because when you say we are not well represented, it clearly indicates that you do not believe in what this particular committee seeks to achieve. Number two, Chair, it's just a question not necessarily based on his own presentation or his response. In numerous public hearings that we have held throughout the country, there was minimal participation of AfriForum in those public hearings. I just want to find out from Mr. Root, what informed this? Why were members of AfriForum not on the ground in all 9 provinces where we were, where there was a meaningful process to allow people?
Hello?
If
Honorable
there was
Mathazi?
any, Chair.
Yes, proceed.
Yeah, I'm saying it was quite minimal. So I want to check from him, were they fearful of what our people are going to say on the ground, or they just assume that oral submissions and written submissions were sufficient for their participation? Thank you, Chair.
Honorable Mathazi, I said that there are diversity of opinions, and I think Mr. Roots expressed his opinion, but your question is still valid to offer him an opportunity to tell us why he has no confidence in this process, but yet he appears before us. Proceed, Mr. Roots.
Oh, no, Chair, I had raised my hand.
Chairperson.
Oh, okay, let's take the hand before he responds. Who is that? Is that Honorable Shibambo?
Yes, Chair.
Oh, I thought it was an old hand. Proceed.
No, it's a new hand.
Yeah.
Okay.
Look, I think we've made this observation several times that, you know, the way this process is so transparent and democratic, we even allow racists to come and speak in parliament and say that this parliamentary process is not legitimate.
On a point of order.
Representative of
point of order.
Themselves.
Yes, Honorable Shibambo, let's hear the point of order.
Did I hear the Honorable Shivambu insult the presenter by calling him a racist? If so, that's unparliamentary. He should apologize and withdraw that terrible remark.
He never said somebody's by name is a racist. Generally, we allow racists.
I said as part of this process, we allow all sorts of characters from different creed and form, including racist children and kids who come and undermine this particular process. That is what we've been doing, listening to absolute nonsense and rubbish from people who are saying that they were not legitimate. Why would you even suggest that a democratic parliament that has been voted in by a huge percentage of eligible voters is not legitimate? Is it because it's not a white-only parliament which legitimated the land in colonial dispossession and apartheid that banished our people to small pieces of land here in South Africa? And a democratic parliament which is majority black, we say, no, this parliament is not the representative of the people. What other mechanism do you want to be represented in this particular process? So it's only legitimate when it's white only. What kind of nonsense is this? And then we must listen to this. Let's hear, Chair, but I think some of the things were just being taken for granted here and deliberately being provoked. But we know what is the intention. Let's listen to the response of this boy.
Thank you, Honorable Shibambo. Honorable Dr. Mulder, I don't think that it is wrong to make an inference that a certain conduct could be informed by racism. But Honorable Shibambo did not say anybody is a racist. And that's why I did not rule him out. So let's proceed. Mr. Roots, can you address us?
Chairperson, I wanted, I think.
Who is that? Is that Honorable Dr. Ngozi?
Yes, Chairperson.
Proceed.
No, thanks, Chair. I thought that it's important to make, not to miss the opportunity, and maybe you will do it, Honorable Chairperson, at the end. And here, I really think we must not miss the opportunity to put our foot down. Surveys from an empirical point of view, if empiricism is science, surveys can never empirically rise to the factual accuracy of elections. A person comes to us and says, we're illegitimate as parliament. At some point, Chairperson, we must be able to at least evoke our authority, because we actually do have it. Whoever does not believe in us, don't talk to us. Whoever does not think whoever thinks we're illegitimate, don't talk to us, because we're not scared of you. We're not scared of anything that you can do once you conclude that we are illegitimate. Everybody that comes and we give them audience, who goes around talking to illegitimate people, Honorable Chairperson? Who goes around, spends their time talking to illegitimate people? It is wrong, and I make it unequivocal that it is motivated by racial patronization that actually informs AfriForum. You ask them, why go to the UN, leave democratic structures here? He answers, goes and says, they don't trust in parliament, they don't think it's legitimate, it does not represent the people of South Africa. Who are they to say that? Why talk to us? Why talk to us if we're illegitimate? These people are wrong. And I am saying that they are saying that because they are racist as an organization. Roots is racist. Thank you.
Honorable Ngozi and honorable members, wrongly or rightly, I believe that we should not waste time on unfounded statements or opinions, because this parliament members of this parliament were elected by the majority of South Africans, both black and white. So it cannot have any substance that the parliament is legitimate. I think that must be dismissed with the contempt that it deserves. Honorable Ruth, address us, please. Mr. Ruth, please.
Thank you, Mr. Chair. And I've noted the disagreement within the EFF with Floyd Shivambu vehemently disagreeing that me or AfriForum are racist, but Ndlozi stating that it is the case. I'll respond to.
That is not true. You are racist, Roots. You don't misrepresent me. I said I'm referring to you are racist. Don't try to put your words in my mouth. Racist fool.
Okay. Thank you.
Honorable Mr. Roots, don't interpret other opinions. Respond to the questions. I think all members made very clear questions that deserve your attention. Please answer.
Thank you, Mr. Chair. I will do so. Firstly, I'm not sure, Mrs. Mahlachi, why she says that AfriForum didn't participate in the local meetings, because we participated in virtually.
Honorable Chair, 1 second. I don't want to be rude, if I may. I can see here on the platform, just to assist Chair, Honorable Klaba's hand is up, probably because I was tempted to raise my hand as well. Probably he will cover what I was going to say if he can be given an opportunity before it's Lesoma, Chair. So Klaba's hand is up.
The hand?
Mr. Klaba, Honorable Klaba.
You want to speak now?
I thought because he had his hand long time ago.
I see. I did.
Yes.
Okay, I didn't see that hand. Honorable Klaba, please proceed before the answer.
Yes, thank you very much, Chair. And
Honorable Klaba,
can you hear me, Chair? Can you hear me now?
Now can you?
Yeah, we can hear you.
Yes, my hand was up earlier because I wanted to comment on the comment made by Mr. Roots. And I find it disappointing that he would come here and say, in short, I don't recognize you. And because all what is said was an equivalent to saying just that, I recognize you. And he still expects us to take him seriously and apply our mind on the presentation that a body as big as AfriForum has made before this, before us. Why must he think we must take him seriously? Why must he think we must apply our mind on his presentation where he is so bold in saying, I don't recognize you? I'm putting it in my own words, but all what he said, it boils down to just that. I thought I should just leave it at that. Thank you so much.
Thank you, Honorable Kaba. I think that will assist Mr. Roots to address this gathering. Mr. Roots?
Thank you. Thank you, Chairperson. I didn't say that Parliament is illegitimate. I didn't say that we at AfriForum don't recognize Parliament. What I said was that politicians in Parliament seem to be out of touch with realities on ground level, that they do not properly represent people, because if you ask people what they think are important, what should be done, and if you ask many people in Parliament, probably surely not all of them, undoubtedly not all of them, but many people in Parliament, if you ask them what their priorities are, it's completely detached from what the priorities of people on ground level are. That's what I'm saying. I'm not saying Parliament is illegitimate. I'm not saying that we don't recognize Parliament or anything like that. That's a strawman, with all due respect, Mr. Chairperson. AfriForum did participate in these meetings, virtually every single one of them in all of the provinces. I spoke at 2 of them. Our members spoke at, as I said, in virtually all of them. So we were there, and we believe that we should participate in this process as we are doing now.
Hello, who's that?
Can you continue, Mr. Chair?
Yeah, proceed.
Chairperson.
Okay. Yes.
It's Mahlatsi. I'm sorry to interject like I am now. And I maybe Mr. Root is not aware that there was never a public hearing that was virtual. Is he
Honorable Mahlatsi, with respect, allow the speaker to finish. If there are other things that you want to raise, I'll give you an opportunity, but we shouldn't interrupt him when he's speaking. Mr. Roots, proceed.
Thank you, Mr. Chairperson. So yeah, the point is that we do believe that this is a process that we should participate in. Our concern is that the issue of this push for land reform, and particularly expropriation without compensation, does not take cognizance of the realities on ground level. And if there's a problem with some of the statistics that we have quoted or I've quoted, we can surely review them or revise them. But you cannot. It's not really an argument to say your statistics are wrong without giving better statistics, or to say this is why the statistics are wrong. If they are wrong, then we should stop using them. If they aren't wrong, then we cannot simply just say these statistics are wrong because we disagree with the point that they raise. So, Mr. Chairperson, we can all pretend that we are very important. We can all pretend that the people in South Africa have great respect for Parliament, and that the people in South Africa love their politicians and the people who work in Parliament, but that doesn't detract from the humor and the irony in the fact that a corruption connoisseur like Floyd Shivambu is trying to lecture us on how to properly run a country.
No.
Honorable.
No, Chairperson.
Honorable Roots.
We are not going to be abused by this racist boy here.
No, Mr. Roots.
Yes, Chairperson.
I advised you not to run commentary on what other people said.
No, you must withdraw. You must withdraw.
You must withdraw. Leave us. That must be put to you, Mr. Roots. Please take this meeting seriously. Withdraw and return to answering the questions.
Mr. Chairperson, don't you think it's unfair if the members of parliament make all sorts of atrocious accusations towards me and towards AfriForum and towards our members, and you allow that, but if I respond, you tell me I must withdraw?
Mr. Roots, I say the questions put to you were very clear. Focus on answering the questions, not on commenting on other things. The questions were clear. Can you deal with the questions?
Chair?
Yes.
Can you recognize me?
Yes.
I'm rising on a point of order, Chair.
Yeah.
I just want to speak really on behalf of all the presenters.
Who are you?
Honorable
Noku?
Yes, Chair.
Okay, proceed.
Chair, I just want to really speak on behalf of the presenters that are still coming. Really addressing you, Chair. I understand that we are here, Chair, to engage the presenters and to get clarity on the question, on the presentation that they are making. But my worry, Chair, is that you are allowing arguments with the presenters, and especially from our side as parliamentarians. I think, Chair, it's very important that we cannot instill our views onto the presenters. That is something that you got to rule on, Chair. Otherwise, you're making this public hearing a challenge. We are here to listen, to take note, and to ask questions for clarity. Many other things, Chair, we will come into our committees and we'll deliberate and look at what is facts, what is not facts, and then obviously debate on the bill itself. Can you please just allow the presenters to present and allow the parliamentarians to ask questions for clarity, not to instill views onto the presenters or argue with the presenters? Thank you, Chair.
Honorable Masipa, that's what I said from the right at the beginning. And that's why I've said the questions put by the honorable members are clear and straightforward, that Mr. Roots must answer those questions and not debate the merits or demerits of the opinions of honorable members. Mr. Roots, proceed.
Thank you, Mr. Chair. I believe I have answered the questions. If there's a question that I haven't answered, someone can please point that out to me.
Chairperson, we are finished. Can we go to the next presentation?
That's why I'm
before that. Though, Chairperson, Mr. Roots was requested to withdraw and he never withdrew, but okay, I can see, let's respect you. But what I want to say,
what is that?
As a follow-up question is, you see,
I don't know if I can speak. Ask this guy. It's fucking racist.
Honorable Rosetta.
Yes,
we had allocated 15 minutes. We had allocated 15 minutes.
As
we
it
don't
clubs.
want to disadvantage other presenters.
Okay.
I think we got what we wanted from this man. Let's allow him to go and we move on.
Okay, but otherwise, thanks very much, Chair.
Okay.
If that is.
And Honorable Mathatsi, also, I just want to say to yourself that Parliament has competent staff. They've kept good records of participation in the public hearings. So we are not going to rely on what Mr. Roots is saying because we have records ourselves. So let's leave that matter. Dr. Gondwe, what do you want to say?
Thank you, Chairperson. Chairperson, there is someone on the platform by the name of Sinawo Tambo. This particular individual has just, I don't know who he was referring to, but he used the profanity and he called someone racist. So I'm not entirely sure who he was referring to, but I think that you should take note of that.
Ernst Roots, the racist.
But Chairperson, I thought you are closing. You stopped me from contributing. I thought you were closing.
No, Honorable Murasata, don't teach me how to conduct the meeting. Honorable Gondwe had not spoken, and I don't want to be accused of suppressing any view. But what she's raising now is irrelevant. She doesn't even know what the remarks, to whom what the remark was directed. So that is not something that we can entertain. Can we proceed to the next
even went ahead and repeat the same comment again?
Honorable
must withdraw that.
Advocate Romano.
Chairperson?
Yeah.
Can you just appeal to members of the public who are on the platform not to participate in the discussions?
Can you raise your voice?
No, I was just saying, can we request members of the public who are on this platform not to participate in the discussions?
Yes, I think it is a well-known practice that members of the public should not participate, but are allowed to observe. So I hope that they will respect that position. Can we proceed? Who is next?
Chair, quickly. So, Sinawa Tambo is a member of parliament. He's not a member of the public, if that is what Bonan was referring to.
Oh, I see. No, thank you for that information. Let's proceed. Who is next submitter? Advocate Romano. Advocate Romano.
Yes, Chair. The next presenters will be from the Banking Association.
The what?
The Banking Association of South Africa.
Okay, thank you. Banking Association of South Africa, the submitter must introduce him or herself.
Thank you very much, Chair. My name is Bongi Kunene. I am the Managing Director of the Banking Association of South Africa. I have with me Mosidi Melamu, who's going to drive the slides. If we could have access to share our slides with you. We would like to thank this committee for inviting us to make the presentation. We had submitted towards the end of the year during the time of written submissions. So today I would like to be brief and just touch upon the points that we would like to highlight. Mosidi, slides, please.
I'm waiting to be made a co-host.
To save time, I'm going to continue. You just start with slide 3, please. This is just to say who we are, Chair. BASA, we're an association for bankers. We advance the interests of our members with regulators, legislators such as yourselves, and other stakeholders. We want to make sure that banking in South Africa remains sustainable, profitable, and better able to contribute to the social and economic development and transformation of our country. As an industry association, Chair, we want to acknowledge first and foremost that the current land ownership and food production in South Africa is not sustainable. And that has its origins in colonialism and apartheid. We as BASA, we are committed to supporting sustainable land reform that will enhance inclusive economic growth and food security. So looking at the subject today, the 18th Amendment, we would like to start by saying that we accept that the 18th Amendment Bill is the outcome of a democratic process. This is rooted in the legislative sphere of our country. The amendment is very explicit that, I quote, "The expropriation of land without compensation is a legitimate option for land reform." We agree with this. And land reform can be undertaken in a legal, constitutional, inclusive, and sustainable manner, which does not dilute property rights. Therefore, for us, land reform must be implemented faster and more effectively, especially in urban areas where according to the statistics, about 1.2 million families live in informal settlements. BASA is committed to working with all stakeholders through all forums that are available to us. We just highlight one forum here, which is the Presidential Land Summit. We want to ensure that there is a swift and sustainable implementation of the land reform progress. The 18th Amendment says that a court may, where land and any improvement thereon are expropriated for the purpose of land reform, the court may determine that the amount of compensation is nil. As BASA, we want to come out and support the provision for the courts to determine whether compensation should be nil. Judiciary balances imperative to accelerate land reform with the independent determination of remedies. We know that legal costs are often prohibitive for citizens. Therefore, we favor a system of mediation whenever there are disputes. Chair, I quote again the 18th Amendment, where it says that the national legislation must set out specific circumstances where a court may determine that the amount of compensation is nil. In this respect, I want to highlight a few issues. The first being that we want to maintain that the arbitrary deprivation of property is not permitted by the Constitution. If land and any improvements thereof will be defined in legislation or by the courts, then this should be explicitly stated. There should be compensation for improvements which are not paid for by the state. Fundamental rights can only be changed through a 66% majority in Parliament, sir. Our concern as BASA always will start with financial and economic stability for the country. Banks hold 5.9 trillion of South Africa's deposits money, and they have extended out of this mortgages to the value of 1.6 trillion in property finance. We adhere to the South African Banks Act and Basel regulations, which require that banks must have sufficient capital and liquidity to return deposits on demand. Therefore, if land is expropriated at below market value, that will inhibit the bank's ability to provide credit where property serves as security. And the important fact in our law is that once you have taken a credit as a bondholder, you are liable for the full debt, even on expropriated property, because at all times, banks must recover their depositors' funds. Land reform, therefore, need to be undertaken in a legal, constitutional, inclusive, and sustainable manner, which continues to protect community rights and property rights, Chair. So I will end here and we will take questions. Thank you very much.
Thank you, Ms. Sbongile. Honorable members, let me just remind you again that we are not here to debate the merits and demerits of submissions. We are here to listen and put questions for clarity. Because if we start this debate, this meeting is going to degenerate into something that is not desirable. So I'm opening the floor now for members who want to ask questions for clarity. Can you show your hands? I don't see any hand now. Dr. Melder, Honorable Dr. Melder.
Yes, thank you, Honorable Chairperson. Thank you to the presenters for the presentation. The presentation makes provision, and it says that BASA supports the provision for courts to determine if compensation should be nil. Could BASA perhaps indicate under which circumstances they are of the view that compensation could be nil?
Thank you, Dr. Melda. Any other hand? I don't see any other hand. Honorable Mahlatsi.
Thank you very much, Chairperson. Let me also appreciate the time taken by BASA to make a presentation to us. But I just want to ask the presenter that what informs their decision, if I can call it a decision, to rely on the courts to determine the compensation? What informs that decision? Do they not believe that the executive has more responsibility, given its constitutional responsibility, by the way, to run business of government? Why should the courts be the ones be the determining factor? My second question, Chair, is the intention or the primary business of the banking sector is to make profit. Now, looking at the statistics or the figures that have been presented to us, that 1.6 trillion is on the mortgage. I just want to find out, maybe from BASA, how much profit is the banking sector making on annual basis, maybe an estimate, and whether does BASA as an institution willing to share those profits with the marginalized South Africans who might have suffered enormously because of the land issue that we are discussing here. How much are they willing to work with government if this particular process go through, and how much are they willing to give in as part of their profit? Thank you, Chair.
Thank you, Honorable Mahlatsi. Honorable Shwambo.
No, thanks, Chair. I wanted to ask a question which, if the Banking Association cannot respond to now, must perhaps give us a written response. How many houses have you repossessed from black people, from people in general? How many houses have you repossessed from people that had borrowed money to buy houses and to buy pieces of land? And what is the racial composition of those repossessions? Just out of how many people do you take care? Because we know that in many instances, banks are repossessing particularly black people's houses, even in instances where those houses were paid 90% towards completion. And then a black person loses a job, the banks ruthlessly take those houses from those people. Can we be given that statistic so that we can be able to locate your objection to this process in clearer context in terms of what we stand for in terms of these issues? Please give us that statistic of just how many houses have we repossessed from our people. Then we'll then be able to understand you.
Mrs. Bongile, the question asked by Honorable Mahlatsi on the role of the courts refers to what the lawyers call the doctrine of separation of powers, which allocates different responsibilities to the executive, to parliament, and to the judiciary. Now, your suggestion actually would affect the architecture of the Constitution, which allocates different powers to different branches of government. So I want to address that very clearly, and also the questions raised by Honorable Shibambo proceed. But before you answer, let me check if there are other hands. I don't see any other hand. Honorable members, I want to request that you raise your hands now so that when the presenter starts responding or has responded, you don't come back and raise your hands, because we have allocated 15 minutes to this process. Are there any other hands? So if there are no other hands, I'm going to allow the presenter to respond, and then we move on.
Thank you very much, Chair. The first question was, under what circumstances will BASA agree with the courts that the determination of compensation can be nil? The circumstances, Chair, will be determined by the courts. We do adhere to the laws of the land, and if there is any court challenge or there is any clarification that any respondent or applicant that is affected by expropriation, they go to the court, and if the ruling of the courts, including the highest court in the land, end up saying that that expropriation must be zero, no compensation, the banks will adhere to that ruling. And it doesn't have predetermined circumstances, because we cannot go through all the permutations of who will want to go to the court under what reasons. So what informs BASA's decision to rely on the courts was another question from the honorable member. It's a reliance on the system that we have currently. We know the separation of powers, and we believe in the sovereignty of each of the institutions of our state. Therefore, if the legislature has deemed that there is a law and it's talking about compensation at zero, that would be the law of the land. However, there isn't a law that cannot be challenged. If there are any challenges to that law, we will be informed by the testing of each of those laws as it goes through the various layers of our judiciary. And the ultimate one, of course, is where we will say we have understood the court ruling and we will abide by it. The other question, Chair, was about the 1.6 trillion that is in mortgages. So maybe I should just be clear here that the mortgages that I'm talking about, they include agriculture land, residential properties, commercial and industrial mortgages. That which is home ownership of this number is about 1.1 trillion. So how much profit the banks are making, this month being the month of March, where the banks have to publicly declare their profits as they are issuing their results. You may recall that all the banks have gone through the process of declaring their profits, and this year, for the first half of their reporting, there is a 48% decline in profitability for all the banking industry in South Africa. So if you are asking about the annual profits, that would be a question that we would say, let us see what comes in the next reporting period. For now, we know that there is a 48% decline. How much will be shared with the marginalized? Incidentally, every year, the members of BASA have programs where they share with the marginalized of our community. I do have the number of how much that is. I just don't have it in front of me. So I don't want to speak in 10 out of 10, Chair. I will submit that to you in writing. Similarly, with the last question, I would like also to submit that in writing. Thank you very much, Chair.
Thank you very much. Can we allow Kasak to take the floor?
Good morning, Chair. Thank you very much. We are indeed here. I hope you can hear me. My name is Lawson Naidu. I am the Executive Secretary of the Council for the Advancement of the South African Constitution. I'm sure you will have seen the written submission that we made a year ago to the committee, and I assume it is on the basis of that submission that we have been invited to address you this morning. I will highlight some of the aspects of that submission that we made, and I might just point out for the benefit of the members of the committee that the submission was drafted by Advocate Tembeka Ngukatobi, who is a member of the CASAC Council and assisted in the drafting of that report. I think we want to make it clear right at the very beginning that CASAC supports the process of land reform in South Africa to alter the skewed landholding patterns, and we believe that the history of land dispossession needs to be urgently addressed. We are also of the view that the assumption behind the proposed amendment is that the Constitution presently does not allow for expropriation with no compensation. In our view, this is an incorrect interpretation of the Constitution. And therefore, the first part of my submission will focus on why this is so, and the second part focuses specifically on the proposed amendment and illustrates why, without fundamental institutional changes, these amendments will not likely bring about sustainable land reform underpinned by the rule of law. I need not emphasize to the committee that this is the first time that an amendment to a clause in the Bill of Rights is being proposed. And we believe that this should be done only in exceptional circumstances and where it is necessary beyond any doubt. The highly contested nature of this proposed amendment suggests that perhaps those conditions have not been met. Without some fundamental changes to the entire program of land reform by the state, it is not likely that any changes in the Constitution or the law will shift the landholding patterns to achieve the vision of the Constitution. And therefore, we believe that the areas of focus for land reform should be, firstly, institutional reorganization. The Commission responsible for restoration and restitution of land rights needs a new mandate and additional resources. It has failed to provide a proper institutional base for land reform. Secondly, it needs to focus on corruption and looting in land reform. There are many indications that land has also become a site of corruption. Capture of the land reform program by the elite presents a danger as great as the failure to distribute land to those who need it most. Thirdly, that the resolution of existing land claims in accordance with the order of the Constitutional Court in the case of the Speaker of the National Assembly and another against the land access movement of South Africa and others provides guidance in this regard. Fourthly, a clear policy decision to focus on redistribution of land to those in need. While the restitution of land to those who are dispossessed remains important, it is now plain that land restitution itself will not resolve the shortage of land to those who need it. The central challenge of the state is to shift its focus towards a framework for the redistribution of land based on need. Fifthly, to affirm the centrality of the rule of law, no land reform program can succeed if it is not based on the rule of law. There is again a risk of elite capture of the land reform program to benefit state officials, politicians, and those with access to funds. The primary purpose behind Section 25 is to transform property ownership patterns from the colonial and apartheid past to a future based on equality, dignity, and freedom. Land ownership, however, is not the only story. The manner in which the rights of occupiers of land who have no rights of ownership, how those rights are regulated is an important function of Section 25. And it is the primary constitutional function of the legislature to undo the legacies of dispossession. Because of the centrality of land dispossession in South Africa's history, Section 25 is the primary institute for the transformation of these land rights. Expropriation of land is expressly mandated and allowed for in the Constitution. Unlike during the days of apartheid, expropriation of land is now not confined to state acquisition of land only for state use. Now, land can be expropriated for general distribution to the public. This much is plain from a reading of Section 25, subsection 2 of the Constitution. Much of the focus has been on the phrase subject to compensation. This has been wrongly interpreted, in our view, to imply that compensation is compulsory for all instances of expropriation. We submit that the whole of Section 25 must be placed in its context to understand the compulsory nature of compensation. Firstly, Section 25 does not contain a right to property. Instead, it protects property holders against the arbitrary seizures of their property. But if property is taken in terms of a law of general application and according to due process, that would not constitute an arbitrary taking of property. Secondly, any compensation payable must be just and equitable. In practice, however, this is contradicted by the government, which has often paid market value for expropriation. Courts also have tended to prioritize market value above all other considerations. Thirdly, Section 25, subsection 8, expressly provides that no provision of this section may impede the state from taking legislative and other measures to achieve land, water, and related reform in order to redress the results of past racial discrimination, provided that any departure from the provisions of this section is in accordance with the provisions of Section 36(1). The Constitution, as I am sure we are all aware, recognizes three forms of land reform, all three of which are designed to address racial discrimination. The promotion of equitable access to land envisaged under Section 25(4) and 5, which is land redistribution, provision of secure tenure under Section 25(6), and thirdly, restitution of land dispossessed after 19 June 1913 in terms of Section 25(7). Now, land reform is often regarded primarily as relating to agricultural land, and there is no reason why that should be the case. The idea of equitable access to land is not only about the amount of land that is owned by different race groups, but it also relates to where that land is owned. Measures that are designed, for example, to address apartheid urban geography should also qualify under Section 25(8). For example, measures to access land in inner cities to make them available to Black people who have historically been forced to live on the outskirts of cities. It must also be accepted that reducing compensation and altering the manner in which it is determined are not on their own the answer to all of the issues. The state must still put in place mechanisms, for example, to speedily assess contested restitution and labor tenant claims by significantly increasing the capacity of the Land Claims Court and the alternative dispute resolution mechanisms that the legislations permit. To provide the necessary pre and post restitution support to communities and occupiers of land to ensure that they make effective and equitable use of the land. And thirdly, to ensure that, particularly in the former homelands, that secure tenure to the land are not subject to the whims of traditional leaders or errant public servants. Just yesterday, we heard the Minister, Toko Dudiza, telling the Portfolio Committee that the officials in her department do not have the necessary skills to effectively implement a program of land reform. So without these and other related reforms and investments, land reform will remain ineffective, even with alternative compensation mechanisms. Allowing expropriation without any compensation is unlikely to be upheld by the courts as a default rule. However, we do want to stress that it is possible to expropriate without compensation in limited circumstances. And the four circumstances that we outlined are firstly, where the land is abandoned or unused. Secondly, where the land is held purely for speculative purposes. Thirdly, where the land is unutilized and owned by public entities. And fourthly, where the land is actively farmed by labor tenants in the absence of the title deed holder. Those are grounds we believe where expropriation without compensation would be appropriate. And we assume that in these instances, the purpose of expropriation will be for land reform and not for other public purposes, such as the building of roads and dams and so on. it is clear that expropriation without compensation outside the land reform context is not justifiable. And it is also doubtful whether expropriation of land alone will be sufficient to meet the significant demands for land reform that I've already alluded to. What may provide a far more effective way to achieve a sustainable land reform is to combine expropriation without compensation in limited circumstances with limited compensation in other circumstances. In relation to the proposed amendment, the amendment is contained in a proviso which states that provided that in accordance with the subsection, a court may, where land and any improvements thereupon is expropriated for the purposes of land reform, determine that the amount of compensation is nil. The question arises of what that proviso means. On the most sensible reading, the proposed section means that a court may determine that in a particular case, land or improvements of land may be expropriated for nil compensation. But it is not clear when this will be the case. How does an owner of land know that their land is liable to be taken without compensation? These questions are not answered in the proviso, but in another proposed amendment, which enables national legislation to be passed to set out these circumstances. There are also some other further ambiguities in the proposed amendment, assuming that land falls within the category identified in national legislation for expropriation. How will a court determine if it should in fact be taken without compensation? We propose that this should be answered by the formulation of just and equitable, which is the centerpiece of the existing Section 25. So if land falls in a category identified by national legislation for the compulsory taking without compensation, a court must apply the formula of justice and equity to finally determine if it should, in a specific instance, be taken without compensation. The power to decide whether compensation for expropriated land should be paid or not lies with the courts, not with the state. The current formulation to Section 25(2)(b) provides that any compensation to be paid to a property owner must either be agreed or decided or approved by a court. We submit that when read with Section 1C on the principle of the rule of law and Section 34 providing for access to the courts, Section 25 must therefore be construed as requiring the courts to determine just and equitable compensation in all instances where this is in dispute. In conclusion, Chair, a final feature of the amendment is the importance of the rule of law. The centrality of the courts as arbiters of disputes in society is entrenched in the Constitution. Not only is the law supreme, but judicial pronouncements are final and binding on other organs of state. The amendment affirms this. Only a court may decide whether or not no compensation is to be paid. A flexible standard of just and equitable should still be applicable in cases of disputes over compensation. There are some who have criticized this because it may slow down land reform because disputes about compensation are notoriously slow to resolve in courts, as other presenters have already highlighted. But we would submit that the rule of law is crucial to avoid arbitrary decision-making. Another important element of the rule of law is the absence of wide executive discretion. We note that the amendment curtails this executive discretion by leaving the contours of the law which may allow expropriation with no compensation to the legislature. The legislature will have to define which land, for what purpose, and for what payment. In closing, we wish to state, however, that the true challenge of land reform still lies in the combination of weak and dysfunctional institutional structures, corrupt officials, greedy landowners, and the absence of a people-centered ethic in the political class, and the failures of the legislature to pass legislation despite the obligations that it has under the Constitution. Recently, the Constitutional Court accepted that the failures in land reform must be placed squarely at the doors of government, not the Constitution. The court summarized the findings of the Motlanthe panel in these terms, and I quote, "The panel set out with stark simplicity the deficits in land reform. Despite the cutoff date for land claims being 1998, To date, there are more than 7,000 unsettled claims and over 19,000 yet to be finalized old order claims. The panel exposes the extremely slow rate of restitution claims, concluding that it will take up to 35 years to finalize all old order claims, 143 years to settle new order claims, and if land claims are reopened, up to 709 years to complete the process of land restitution. Institutional capacity is evidenced in the lack of skills and capacity, overlapping and conflicting claims, and inconsistent monetary awards. A possible explanation for these shortcomings is the lack of sufficient resources. However, the budget for land restitution has been consistently underspent. This evidences how severe problems lie in implementation and the capacity of the system itself. That's the end of the quote. It is by refocusing the debate to these known challenges that land reform can be meaningful. A constitutional amendment will only provide superficial succor to this pain of landlessness. Its ultimate resolution lies in institutional reorganization. I thank you, Chair.
Thank you. Advocate Ramano, are you there? Advocate Ramano?
I am here, Chair.
Just make sure that all the speakers keep within the time allocated, because we don't want to be accused of favoring other speakers. And please indicate if a speaker is exceeding time. I'm now going to take hands. And as I said before, once the submitter starts answering, we are not going to allow a debate with the submitter. So all those who want to raise questions, they should raise their hands now, not after the speaker has started to speak. But whilst I'm still waiting for the hands, I just want to know from Advocate Naidu, is CASAC aware that in June 1913, African people had only 7% of the total surface of South Africa and its natural resources. When that percentage was increased to 13% in 1936. Now, given that situation, what is your view on the suggestion that Section 25(7) should be removed? Secondly, as far back as 1951, the International Court Commission of Jurists demanded the rule of law, the formulation of the rule of law in the colonial context, to move away from the liberal concept of the rule of law, which favored the colonialists and not the colonized. And that development led to the concept, the African, what I can call a revolutionary or progressive concept of the rule of law, which led to documents, instruments like human rights, human and people's rights. Doesn't that to you suggest to you that we need an African-centered jurisprudence when we deal with the land questions, that we shouldn't just simply say rule of law, because there are different interpretations of the rule of law. Thank you. But don't respond now. I see the hand of Honorable Masati, and then I'll take all the contributions, and then you can respond to all of them at the same time. Honorable Masati.
Thank you very much, Chair. Chair, CASAC makes a suggestion that there should be an internal appeal mechanism in the expropriation process, which I believe the expropriation makes a provision for. Now, in paragraph 64 of their actual submission, they submit that the power to decide whether expropriation or expropriated land should be paid lies with the courts and not government. Now, my question is, what is their understanding of executive authority in relation to executive functions of the state, which are not in the realm of the courts, mindful of the fact that the Constitution provides for judicial review? Now, my second question, Chair, is on the circumstances in which expropriation can happen. I think the gentleman has indicated that one of the circumstances is where labor tenants are occupants of a land without title deed. Does he not believe that instead of that part being a circumstances in which the expropriation can happen, we should generally convert the occupation and give the occupants title deeds instead of expropriating? Now, my last question, Chair, is on the state capacity. He indicates that yesterday, Minister Tokotidis has indicated that there's a challenge in relation to state capacity. I want to put it forth to him that one of the challenges in relation to state capacity is in the research capacity, informed by the restitution process. Now, in my view, Chair, the process of expropriating land without compensation, it gives rise to assist the state to provide land and deal with these other hiccups that are informed by the current legislation. Now, the intention of the process is mainly to redistribute land, but not to restitute. Now, the challenge with restitution is because land has changed hands so many times that it is become impossible for the department to locate the rightful and accurate rightful owners of the land. Now, with expropriation of land without compensation, that process will give rise to a fair redistribution. Doesn't he think that expropriating land without compensation will be the right route to ensure that we deal with the state capacity issue? Thank you, Chair.
Thank you, Honorable Mathatsin. Honorable members, can I assume that there are no more hands? Because I'm not going to take hands when the submitter is responding. Are there any other hands? So there are no other hands. And I also just want to state that if you put 100 lawyers in one room, you can get 100 different legal opinions. So let's accept that Advocate Naidu has given the opinions of CASAC, but when we bring legal resources, NADEL, BLA, Lawyers for Human Rights, they may have other opinions different from his. So let's thank him for having given CASAC's opinion and allow him to respond, and then we proceed.
Thank you, Chair, for those words. We do value the opportunity that CASAC has been given to provide its input on the proposed amendment of Section 25. It is the view of CASAC that we have tabled. We accept that there will be other views, but we make the submission with the intention of enhancing and contributing to the debate that the committee will ultimately engage in to determine the way forward. In relation to the questions, and starting with the question that you posed, Chair, I would certainly agree with you that we need to follow a system of land restitution to acknowledge the historic injustices that we have visited on the people of South Africa in the past through the 1913 Land Act and the other elements of dispossession that you referred to. So our view is very clear that the need for land reform in South Africa is long overdue. It is urgent, but it needs to be done in a holistic and sustainable manner. On the issue of the rule of law and what it means and how it's to be interpreted, I think our departure point there is that it needs to provide certainty. The legal framework for land reform, whether it be restitution, redistribution, or land tenure, needs to be done in a way that provides for legal certainty and provides for ease of knowing what the rights and obligations of the different parties are. In relation to the questions posed by the Honourable Matlatsi, you refer to paragraph 64 of our submission. And here, I think the distinction that we're seeking to make is that the executive, the state, the government, will hold the power to take a decision as to whether to expropriate or not. That is a matter that lies within the domain of the executive. The decision on compensation, however, does not lie within the domain of the executive. That is a matter ultimately for determination by the courts. And that's where we see the separation of powers and where the decision on compensation is taken. In relation to the question around labor tenants, I'm not sure that we disagree on that. What we were saying is that where labor tenants occupy and use the land in the absence of the title deed holder, expropriation without compensation would be appropriate. I'm not sure how one could simply grant title deeds to the labor tenants without expropriating the land from the legal title holder in the first place. So I think it's a question of mechanics rather than the process, because our view is certainly that labor tenants in those circumstances should be entitled to get the title deeds. It's the question of the process to be followed on that. Finally, in relation to the issue of state capacity and research, I think we disagree here, because I think the point I'm making is until we've enhanced the capacity of the state, and the reason I highlighted the comments that the Minister Toko Didiza made in Parliament yesterday was really to point out that there is a serious skills deficit within government, within the Department of Land Reform and Agriculture, to actually implement the existing land reform processes that we have in place. And so I'm not sure that simply adding another layer of expropriation without compensation to the top of that list is going to deal with the issue of state capacity. In my view, it's likely to create further confusion, further ineffective implementation. And until we reach a holistic approach to the question of land reform and really identify what the bottlenecks are, what the budgetary constraints are, and so on. In the quote that I ended with from the Constitutional Court, the court itself made note of the fact that there is continuous underspending by the department. So if budget is not an issue, we need to evaluate why those budgets are not being spent. So we would certainly emphasize to the committee to take a holistic view on this, and perhaps to end off, Chair, just to emphasize once again that we are not against expropriation without compensation. Our view is that land can be expropriated within the current contents of Section 25 of the Constitution. And once again, I thank you for the opportunity of making this presentation.
Thank you, Advocate Naidu. Can we now have Black Land First? Black
Chairperson, good morning.
Good morning to you. How are you?
I'm good, thank you.
No, you look
Chairperson,
good.
I have not followed the conversation, so I don't know how much time I have. It would be good perhaps to be guided.
15 minutes for your presentation, 15 minutes for questions of clarity, not of debate.
Thanks, Chair. Chair, we have already made a submission and I do not propose to read it verbatim. What I wish to do is to highlight certain important aspects of the presentation or our submission, including new developments. Let me start by saying that I recognize all the members. Ideologically, I am incapable of saying honorable because I don't know whether you can say a landless people 26 years after democracy and their leaders can claim the title of being honorable. We are landless, we remain landless in our own country.
Mr. Andile, let me just say to you, we don't want controversies. Parliament has rules that it follows, which were adopted democratically. All members of this committee are honorable members of Parliament, and they should be addressed as such. Thank you.
Chairperson.
Thank you, Chairperson.
Point of order.
Who is that?
This is Ndlozi.
Dr. Ndlozi?
Yes, Chairperson. I think, Chairperson, with the greatest respect, allow the Honorable Mngxitama to critique this question of us being honorable and claiming to be landless. It's a fair comment that must not be suppressed. He's not saying that he's going to break the rules. I'm sure he's not. But it's a good assessment of the title of being honorable.
We allocated time to him to amplify his written submission, not to debate the titles, whether they are right or not. That is outside the scope of the time that we allocated to him. Proceed, Honorable Mr. Andile.
Chairperson, it's good to hear that Dr. Ndlozi agrees with me. I hope he'll agree also on the substantive questions. Now, let's just start by making this claim coming from our submission, and I'm not going to go into our submission verbatim. First is this big question. This bill before you, Chairperson, has got nothing to do with land expropriation without compensation. And this is an important consideration. In fact, we claim that, and in our submission we make the point, it is a monumental betrayal of our people's desire for land after 26 years of democracy. And therefore, this committee, your committee, Chairperson, if it endorses this bill, it will then be complicit in this betrayal, in this monumental fraud, which is being presented as a solution. The bill is shocking, Chairperson, that this bill departs significantly from the intentions of the motion. The motion was there be land expropriation without compensation. In fact, 81% of members of parliament voted for that motion. Now, essentially the object of land expropriation without compensation as adopted by parliament, we understood it to be a mechanism to address the apartheid and colonial land ownership or land patterns. Now, the question I want to propose, because if we don't sort this out, we are not going to make the progress we need. Would, Chairperson and the committee, would land be returned to Black people after this amendment of this bill is approved? If this bill is approved, would we sit with a situation where 80% of the land which is in white people right now would be reversed to a situation where Black people have the land? The answer is no. The answer is simply no, Chairperson. And so we must ask the question, what is then this bill seeking to do? You know, Chairperson, I was thinking about this, and then I was thinking perhaps the best expression is to say, this bill is like if you stole my car and I want it back. Instead of confiscating it, taking it back, I just ask for the wipers, I ask for the mirrors and maybe the worn out tires, but the car remains with you. Because this bill, Chairperson, says there will be enabling legislation where nil compensation will be paid under certain circumstances. And what are those circumstances? Is where white people do not want the land, unused land.
I can't hear the presenter.
Oh, I'm told that.
Hello? 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 Mr. Andile?
I can hear you, Chairperson.
Proceed, Mr. Andile.
You can hear me?
I hear you. Please proceed.
Yes, I understand other members of the committee say they can't hear me, so that was a bit disturbing.
Oh, I see. Advocate Ramano? Advocate Ramano?
Now we can hear him, Prof.
We can hear the presenter clear.
Okay, is that matter sorted out? Can we now proceed?
Yes, let's proceed.
Okay. Mr. Andile, proceed. Mr. Andile? Mr. Andile?
Chair, I can hear you.
Proceed.
Okay, you can hear me, Chairperson?
Yes.
Okay, sure. So what we are saying, Chairperson, is that this bill does not address the land question. In fact, it seemed to us that the logic of the bill is what the proposer of the motion, Mr. Malema, told land thieves in PAL in 2015, where he said, well, land expropriation is about unproductive land. This is the same logic we see in President Ramaphosa, who emphasizes the ANC's own resolutions, which bring us to this idea that land which must be expropriated is unused, unproductive, land where speculation is happening. So it is not about changing the nature of or the patterns of land ownership in this country. If we were to quickly go to the debate of compensation, because this is about compensation, Chairperson. The Section 25 is absolutely clear. You can expropriate land, but you must pay compensation. And we think that was the problem. This problem has not been solved, Chairperson, by this amendment. What this amendment brings in is a notion of nil compensation. Nil compensation for specific pieces of land, which, as I said, are land that we don't need. Now, at this point, Chairperson, I must pause and introduce this conundrum. As we speak now, the Public Works Committee also has a process of land expropriation. Now, Chairperson, you are a lawyer and you belong in Parliament. Section 25 is supposed to be finished, must finish with it, and then only should Public Works start the process of amending the Expropriation Act to fall in line with the expropriation amendment. Now, the truth of the matter is, these two processes are both of them in sync, use the same language, and that language is that there must be nil compensation where white people don't want the land or where they donate land. I'm saying to you, Chairperson, it's an illegal and unlawful process going on in the Public Works process, because they should have waited for you to finalize the amendment of the Constitution, and they must bring in an enabling legislation. But I'm saying already that language of nil compensation, which is in this amendment, find expression in the expropriation bill, so of the Public Works Committee, meaning that Parliament has entered into a conspiracy to speak about land expropriation without compensation, when in fact it's got nothing to do with changing the patterns of land ownership in this country. And this comes from the proposal by Nukaitobi, Advocate Nukaitobi. We present this in our submission. Chairperson, I just want to make as a point of information, and if possible, it will be nice to have a debate with Advocate Nukaitobi, who gives you this notion of nil compensation. Parliament said land expropriation without compensation. Nukaitobi says nil compensation, and then he says under what circumstances? Let me explain to you, Chairperson, that Advocate Nukaitobi, whom you are listening to, is actually an acting judge in the Land Claims Court. He has already attempted to interpret the Constitution to bring about nil compensation, and he has failed dismally. He did not bring that information to your attention, that his decision as a judge of the Land Claims Court around compensation has been overturned by our higher court, the Supreme Court of Appeal. The Supreme Court of Appeal says in each situation where you are going to expropriate land, you must pay just and equitable compensation. His decision of the Land Claims Court was dismissed with cause. So where we are, our courts have already determined, the highest court of the country, the Constitutional Court, has already determined that in each case where there is compensation, we must pay white people a market-related value. That is the law, Chairperson. So what are you doing with this amendment? This amendment has got nothing to do to resolve the issue of compensation, which is the biggest problem of Section 25. So we are sitting here with a situation, therefore, Chairperson, of having to conclude that Parliament and your committee is involved in a massive fraud. But we can change this. How do we remedy this situation? We make several proposals. Firstly, we ask this committee to reject in its entirety this bill. And not only that, this 18th Amendment bill, not only that, you must stop the public works process, which is unlawful. And we propose you draft a new bill. A new bill, draft it yourself, and it must clarify the following. One, it must say, all land in the hands of white people is stolen property. That's what you must say, because that's what we are trying to address. And then it must also say the objective of land expropriation without compensation is to return all land that was stolen from Black people back to its rightful owners. This, Chairperson, is confiscation. We are talking, if we're going to address colonial land ownership, apartheid land ownership, we are talking about complete, total confiscation of all land in the hands of white people, and then setting a process to give it back to its rightful owners. Not this piecemeal process of we must get unused land or unproductive land or land where white people don't want, because that leaves us exactly where we are. Chairperson, we also propose that the enabling acts which must come about, in other words, once you are finished with what we propose you should do, if you want land expropriation without compensation, if you don't want to lie to our people, then an enabling act by the relevant committee must declare that all land in the hands of white people must be expropriated and be given to its rightful owners. Now, let me just bring a caveat there. Expropriation of land cannot include land already held by Black people, such as in Ngonyama Trust, because you are addressing the historical question of land dispossession, land stolen from Black people by white people. Therefore, land already in Black hands must be completely excluded in the process of land expropriation. Otherwise, you are expropriating the expropriated. And we are arguing, Chairperson, that such an enabling legislation, which right now is happening in the Public Works Department committee, must be done within 6 months. We are scared, Chairperson. We are 3 years after Parliament has said there will be land expropriation. Nothing has happened except obfuscation of this question. Now, we ask you, amend the Constitution, Section 25, very simply, remove everything which is there in Section 25, bring in the words that we are suggesting, land stolen from Black people must be given to Black people without Black people paying a cent. Have a legislation that says the same, we are done. But right now, where we are, Chairperson, we're sitting with a fraud. Your process, and I'm challenging this committee, any member of this committee must be, can they answer the question? After we are done with this amendment of Section 25, will land be returned to Black people? The answer is no. So what are you doing? You are basically involved in what we must emphasize over and over again is a betrayal of our people's desire to have land in their hands. I'll leave it at that, Chairperson, so that we can have engagements.
Thank you very much, Mr. Andile. I will now take hands from the honorable members. Honorable Masipa, Honorable Ngozi, any other hands? Masipa, Ngozi, Honorable Masipa, proceed.
Thanks, Chair, and thanks to Ndate Andile. Chair, my question is, I've got two questions that I have just for clarity. Ndate Andile, does BLF believe in non-racialism? And if so, how is the organization really aiming to achieve the non-racialism? That's the first question. The second one, I just want to say that, you know, some presenters did indicate that corruption has been really a problem that derailed the land reform. And Kasak also indicated that that has been evident that, you know, corruption has been a problem. Does the BLF believes that changing the bill is sufficient to address these challenges of the land? Because obviously, you know, there are really serious issues of capacity of the institution to deliver some of the mandated legislation framework. Thanks, Chair.
Thank you, Honorable Dr. Ndlozi. And then I also recognize Honorable Shibambo.
No, Chairperson, I will leave it to the Deputy President. Thank you.
Thank you, Honorable Dr. Ndlozi. Honorable Shibambo.
No, thanks, Chair. Look, in terms of the process, is that what we're engaged in here as the Constitutional Amendment Ad Hoc Committee, once the Constitution is amended, all other legislation is going to have to adhere to what we are amending here. So to the one be a piece of legislation, be the expropriation bill that is going to override the essence of what we're busy with here. I want to check with Andile in terms of his usage of the word confiscation. Shouldn't you refer to it as repossession? Because we all agree that the land has been stolen from black people through colonial dispossession and apartheid and all forms of dispossession. So shouldn't then we say that we should repossess the land that is wrongfully in the hands of white colonial settlers and their descendants? Like, so, because once you say confiscation, you're almost legitimating that those who are holding that land are rightfully owning it, and then you just have to confiscate it. Isn't it much more simplistic to just say confiscation instead of correctly defining this as repossession in the manner that it is? And the other question that you'll appreciate about the Ngonyama Trust is that the royal family, the Zulu royal family, has been custodian of that land, that I think 2.8 million hectares that belonged to the KwaZulu homeland. And the obvious limitations with that was the fact that in the reallocation or the redistribution of that land, in many instances, and factually so, we had this during the public hearings of the CRC process, that majority of the traditional chiefs were refusing to allocate that land to females. They say, you know, in terms of African traditional culture, females are not allowed to occupy the land. They can't be given, they can't even inherit it from their husband when the husbands pass on, in terms of all of those things. And one thing that you must be rest assured is that we are for repossession of all of South Africa's land, and the custodianship and the redistribution role can be played by different authorities, be local government and different departments, provincial and national level, but also by traditional leaders, but within a democratic dispensation and process that will then say that how do we deal with the gender question, how do we deal with issues of same piece of land being allocated to several people, and a variety of limitations that deal with that. But I'm more interested to listening to your conceptualization of confiscation versus repossession, because repossession is in context. So you were in the EFF before. You know that the founding manifesto, which you know, says that we must repossess the whole of South Africa, and then we'll then determine how certain people gain access to land through a legislative process that will then detail that particular process. I don't know how you want to attribute a different context to what we stand for.
Thank you, Honorable Shibambo. Thank you very much. Honorable Mahlatsi.
Thank you very much, Chair. I would also want to pose a question to Ndate Andile. In his presentation, he has indicated that expropriation should only happen to a particular race, but not Black South Africans. Now, in a situation where, because of course there are Black South Africans who own massive land, of which could be redistributed to accommodate the landless. What is his view on the issue? Because that land might also be used for profitability issues, but the fact that a majority of Black South Africans are landless, shouldn't we look holistically in relation to redistribution vis-a-vis the element of restitution? Thank you, Chair.
Thank you, Honorable Mahlatsi. Are there any other hands? Because we won't take hands once the submitter starts to respond. I don't see any other hands. Mr. Andile, can you address the point questions?
Yes, thanks, Chair. However, I mean, I'm a little bit unhappy that the questions that are posed around whether my reading of our reading of this bill is correct, which is to say it does not address the main question, which is that we will end up with a situation once this bill has been accepted with land redress. That question has not been answered. Therefore, I stick with our conclusion that this is a red herring.
Chairperson.
Yes, Honorable Schwam.
Yeah. So this is how legislation writing happens. These deliberations, so the text that is on the draft bill is not final. These public hearings that were engaged in, including your submissions, is part of consolidating what will be the final text. So you can't be asking us questions because there's nothing final here. We're finalizing the text. Make your submissions to say that this is what we think must be in the final legislation. We have no final product yet in terms of how the constitution is going to read like. We are finalizing that process now, allowing all of you to make that particular input into this process.
Thank you for that intervention, Honorable Shibambo. That's very appropriate. Mr. Andile, the honorable members have put straightforward questions to you.
No problem.
Deal with those questions.
Absolutely. No, I will come back to this. The on non-racialism, no, we're a Black consciousness, pro-Black movement. Non-racialism is not something you fight for, a DA member. It's an outcome of a process of justice. The problem we have right now is precisely where you have not addressed the apartheid and colonial problems, and you declare yourself non-racial. As a consequence, Black people are excluded, and white people, some of them, of course, without even appropriate education, are running around as leaders. No, non-racialism for Black first land first, which follows Black consciousness, is not something that we proclaim. It's something that would be a byproduct of justice. Corruption, a good question. For us, the main corruption is the land question. You can't have 30,000 white people, 30,000 in a country of 59 million, 30,000 white people owning about 80% of the land stolen from Black people, and this is not being addressed. That for us is the mother of all corruptions. And if you were serious about corruption, you would then align yourself with the call for land to be given back to its rightful owners. Now, Mr. Shivambu raises some interesting questions around the semantics of whether should we say confiscation or repossession. I thought that, as radicals, we look up to Lenin, 1917 Russian Revolution is a very great example of what you do with land. And in their decree on land, they are clear. You confiscate. You take. For me, it makes no difference whether the question is whether white people claim that they have rightful ownership of the land or not. I'm interested in the mechanism that takes the land from white people and give it to Black people. You call it repossession, great. But show me where Mr. Shivambu, in this particular bill, which is expected to expropriate land, where is the provision for this repossession? It does not exist. What you have done, this committee, I don't know how you accepted this draft. You saying nil compensation for certain pieces of land, which are so small, which are not part of redressal of the land question. So the land, of course, also belongs to the people, not to the state. The state must just make sure that our people have tenure security. And that brings me to the question of the Ngwenyama Trust. I'm not hearing Mr. Shivambu saying that it is a wrong thing for Black people to have land. I'm hearing him talking about tenure arrangement and administration of land. It's a secondary question. How we administer land, how we resolve conflicts and so on. But let us start with the first question first. Me and Mr. Shivambu and Dr. Ndlozi, we are landless and tenants in our own country. We have not resolved the primary problem of land dispossession, land held by white people. We must resolve that question and then deal with the tenure arrangement.
Mr. Andile, Mr. Shivambu correctly said, we are in the process of dealing with these matters. And we expect the committee to have taken a final decision. We're not here to take a final decision. We're here to listen to submissions which will enable us to take a final decision. So I think let's leave matters there. I had recognized the Honorable Ndlozi, but he deferred to his deputy president. But I will only allow him to speak and then we move on.
Thanks indeed, Chairperson. No. Comrade Dandile, I wanted to ask you constant reference to Blacks. What do you mean by Black people? You would know that there's going to be a huge contestation in relation to that terminology. And I hope you understand me. I don't have to clarify. But what do you mean by, you keep saying the land was stolen from Black people. A lot of people like to say that. So I just wanted for you to assist us. It might also disabuse the certain non-racial expectations or multiracial expectations. When you say Black people, what do you mean? Thanks, Chairperson.
Thank you. I think that's a fair question. Mr. Andile?
Sure. We are a Black consciousness organization. We take that definition from Steve Biko. In terms of Steve Biko's definition, Africans, so-called coloreds, and so-called Indians. And it's very important, the qualification on these Indians. Only Indians of South African descent would fall under the terminology Black. But as Dr. Ndlozi would know, to be Black, it's not enough to simply have pigmentation, at least amongst ourselves. You have to take a position which is pro-Black. So somebody like Pravin Gordhan, to make an example, Chairperson, from our perspective, will not be considered Black, will rather be considered non-white. All the Indian people in this country who do not subscribe to the interests of the African majority and go against those will not be considered Black. But when we say Black, we mean all the people who were formerly oppressed, in fact, continue to be oppressed, Africans, Indians, and coloreds. But you must still take a position for Blackness for you to be Black.
Thank you. I think the question was very straightforward. Definition of Black, you have answered it. You say colored, Indian, and Africans. That's enough. Thank you very much.
That's not enough. You must still have the qualification, Chairperson. Biko was very clear. To be Black, you have to take a position for Blackness, because there are non-white who are by pigmentation Black, including those such as Pravin Gordhan and others who are anti-Black.
Mr. Andile, I'm saying that you have answered the question. Thank you very much.
Amanda.
Go ahead and please amend the constitution. The constitution to make sure give us land, not what you have there. Thank you, Chairperson.
Freedom of religion. Freedom of religion.
Good afternoon, Honourable Chairperson and Honourable Committee members. Thank you very much. I will just get the screen share going on the side. Honourable Vunani, if you can just enable the screen share for me, that would be wonderful. Or will you be handling the slide presentation? Okay, wonderful. Thank you. Screen share has been enabled. All right. Okay. First of all, thank you for inviting 4SA to participate in this meeting and to present our input on the draft Constitution 18th Amendment Bill. We trust that our submission will be brief, but that it will provide a unique perspective that will assist the committee in drafting a law that has practical benefits for our nation. I am Daniela Ellebeck. I'm an attorney and the legal advisor to Freedom of Religion South Africa, or 4SA. I also apologize on behalf of my colleagues, 4SA's Executive Director, Michael Swain, and 4SA's Legal Counsel, Advocate Nadine Barnhorst, who are unable to attend this afternoon's meeting. Now, 4SA is a legal advocacy organization working to protect and promote the right to freedom of conscience, religion, thought, belief, and opinion. In this presentation referred to as the right to religious freedom, which is the constitutional right we find in Section 15 of our Bill of Rights. Now, 4SA currently has an endorsement base of religious leaders representing approximately 6 million people in South Africa, and its constituency spans across various denominations, churches, and faith groups in the country. So, what is the ambit of religious freedom? Our Constitutional Court has defined religious freedom as the right to entertain such beliefs as a person chooses, the right to declare those religious beliefs openly and without fear of hindrance or reprisal, and the right to manifest religious belief by public worship and practice or by teaching and dissemination. In other words, religious freedom is the right to believe what you want to believe and to freely live out that belief by words and actions. As a human right, it attaches to you as a human being, not a place you find yourself in or a function that you do. Now, we see that our Constitution protects religious freedom not only in Section 15, which because of Section 8.2 applies not only to individuals, but juristic persons such as faith-based organizations, but also that it protects the right of religious communities. We find that Section 31 says that religious communities may not be denied the right to practice their beliefs together with other members of their community. Now, every week, millions of believers across different denominations, churches, and faith groups believe that the scriptures command their meeting together and that doing so is integral and crucial to practicing and living out their beliefs. Thus, the places where such meetings happen are of central and indeed critical importance to the living out of believers' Section 15 and Section 31 constitutional rights. In light of this, places of worship are a crucial part to the exercise of the right to religious freedom. And our interest in the bill lies therein that millions of believers meet together in buildings located on land in the exercise of these constitutional rights. So what is 4SA's concern with the bill? Primarily, we are concerned that no criteria are included for consideration before expropriation without compensation can occur. The bill only states that such circumstances must be set out in subordinate legislation. Now, we strongly object to the circumstances not being a closed list set out in the bill itself, which will form part of the Constitution itself, but only in subordinate national legislation, which is easily amendable and subject to change. Neither are any exceptions for certain types of property that cannot be expropriated provided for, specifically land used for religious purposes. We object that there are no exceptions because in the absence of any exceptions, the amendment bill is open to having unintended and potentially disastrous consequences on religious freedom and the rights of religious communities, including the potential expropriation of church land or land used for religious purposes. So in light of this, we recommend, firstly, and particularly in light of the state's duty in terms of Section 7 of the Constitution to respect and protect the religious convictions and beliefs of those believers who choose to meet together to practice their faith, that the proposed sections of the bill be more narrowly drafted. In other words, that a closed list of criteria be included in the Constitution itself. Alternatively, that a clause containing land which is exempt be inserted. Here we specifically propose land that is owned and used in connection with the exercise of the constitutional right to religious freedom and the rights of religious communities is hereby exempted from the applicability of section 25(2). Thank you for allowing 4SA to present. I look forward to answering any questions that the Honourable Committee members may have.
Whilst I'm taking hands, can you confirm or deny that some religious organizations were given land as a reward for collaboration with the colonial authorities which dispossessed people of their land violently?
Oh, Honourable Chairperson, I would have to research that and get back to you. Off the top of my head, I'm not in a position to advise that based on fact. If that is something that existed, one needs to look at, in my opinion, if that land is currently still being used for religious purposes.
Chairperson, we can assist quickly. The example is NG Kerk. How can the speaker not know about NG Kerk?
Honorable Ndlozi, she says she wants to go and do her homework.
I am doing the homework for her. I'm doing the homework for her. NG Kerk.
Honorable Ndlozi, I
advise
appreciate
us. We have an opportunity to influence our direction. NG Kerk is an example of a collaborationist missionary in killing people and dispossessing land.
Honorable Ndlozi, we don't want to deal with this matter piecemeal. Let's allow her to do the research and submit something to us. Honorable Murasetla. Honorable
Chairperson. Yeah. You see, though there is very little said about section 25, which we are confined to. Well, she has got a historical background on section 15, section 31, but a simple question. She ended up saying they object to the amendment of section 25. That was the conclusion. But I want to know a simple, a straightforward answer as to whether she agrees with this committee and Parliament that it is true that we have got the land which was dispossessed from the rightful owner, and the attempt or the ditch of Parliament is to take the land back to its own rightful owners. Is she in agreement that the land was illegally taken? You have already cited how the church benefited from the land, but I want her to come to the party and tell us if she agrees that this land was illegally taken away from the indigenous black of South Africa.
Thank you, Honorable Murasetla, for a very clear question. Honorable Dr. Ndlozi.
Thanks, Chairperson. So, I thought there was going to be a very complex appreciation of the centrality of the land in African spirituality. And the fact that a lot of the disruption that came with land dispossession caused a disruption in the ways in which people practiced their spirituality. So I would be interested in the speaker to speak to this question, the relationship between African spirituality, African religious practices, and the fact that Africans do not have land. And they don't have land because it was criminally taken from them and then kept away from them because of the color of their skin. So for 500 years, that religious relationship has been violated. That is my question to her. Thank you.
Thank you, Honorable Dr. Ndlozi. Any other hand? No hands. I will allow the speaker to respond to the questions put.
Thank you, Honorable Dr. Mocheka. First of all, perhaps let me start by saying that for those of the committee members that have worked with us previously, for example, Honorable Chairperson, they would know that amongst 4SA's constituency, we do include African spirituality churches. For example, when it comes to some of the lockdown issues that we've been involved in, we have represented over 18.5 million people, most of those from African spiritual and African religious backgrounds. So I do apologize for not knowing about the Dutch Reformed Church. I'm not a member of the Dutch Reformed Church. But my point was saying that the question would come down to whether or not land is being used for religious purposes. So the idea would be, and that's the crux of 4SA's submission, is that if land is being used for religious purposes, and I agree with Honorable Ndozi that it's important that people who have been deprived of being able to use land for religious purposes, such as many communities in the African spirituality and religious backgrounds, be given access and be allowed to, access land. Many of the churches that 4SA works with, many of the other faith-based organizations that we represent do not own their own land. Most of them rent land, so the members will be able to appreciate how, for example, not being able to meet together in school halls during COVID has negatively impacted on their religious freedom, and that's another big issue that we're sitting with. But the crux of the matter of our presentation is that we're not saying don't expropriate. We're saying when land is being used for religious purposes, don't further limit the ability of people to practice their faith by taking that land away. And that is the proposal that we've submitted. That was our recommendation, is to put in a closed list of factors that need to be for consideration and perhaps put in an exemption for land that is being used for religious purposes. So that, for example, if a field is being used, by a faith-based organization for their meetings there, that field not be expropriated because it's being used for religious purposes, perhaps in line with many of the African spirituality practices that I am aware of. I trust that answers the committee members' questions.
Thank you very much. Let's move on to National House of Traditional Leaders.
Thank you, Honorable Chairperson of the session and the committee. And let me thank the committee for affording us the opportunity to come and present on the review of the Constitution and the amendment of Section 25. As the National House of Traditional Leaders, our main objective is to deal with matters relating to traditional leadership, the role of traditional leaders and customary law and customs of communities observing the system of customary law. As the House of Traditional Leaders, we acknowledge the legacy of exclusion and marginalization from access to land brought about by colonialism and apartheid that resulted in the challenges of poverty, inequality, and unemployment in South Africa, and more so in rural areas. It is appreciated that at least or at last, Parliament has realized that the Constitution has some shortcomings and that it is necessary for it to be reviewed. Amakosi have been hammering on the need for review for a long time. We're in the process of coming with proposals for the review of Section 7 and 12 of the Constitution. It is clear that some pieces of legislation dealing with land reform programs have failed due to serious lack of vigorous implementation, consultation, constitutional stumbling blocks, and intentional barriers for ownership and control by certain groups pertaining to programs such as willing buyer and willing seller. In terms of the history of communal land system and the impact of colonialism, the system of communal land occupied and used for rural community residential and grazing purposes was adulterated by colonial and apartheid governments. This resulted in the dispossession of African traditional communities of their ancestral land at no compensation. Where traditional communities acquired land privately prior to the enactment of the 1930 Native Land Act, such land was registered and held in trust by government. Traditional communities have subjected themselves to a foreign manner of land allocation, land use determination, and settlement without any cognizance of the communally established and accepted land rules and communal land administration systems. Any claims by traditional communities for the restoration of land from which they were dispossessed have not been finalized. So the Department of Rural Development and Land Reform decided that communities dispossessed of land in the former TBVC states and self-governing territories could not lodge claims for the restoration of their ancestral land. Traditional leaders have fought fiercely during many different wars of dispossession, such as the 1906 Bambata Rebellion, the 1883 Mapogo dispossession, which led to people being subjected to indentured labor, the Insa Wars, the Nine Frontier Wars, the Kohensen Wars, the Battle of Sandwan, and many, many more wars that were fought by traditional leaders fighting land dispossession. One of the frustrations for land reform has been around non-finalization of the land claims by government for traditional communities. The Bakatla Constitutional Court judgment is also problematic to the institution, as it creates two governance systems in one traditional community. The other frustration for traditional communities is that when traditional communities claim land, the return of the dispossessed land has been to the structures that were never dispossessed, contrary to the initial ownership of that land in the form of CPAs that have brought serious challenges for social cohesion and nation building in the form of fraud, corruption, greed, killings, embezzlement of funds, robbery, and many others, and many traditional leaders have been subjected to this. What kind of redress is this? Land must be returned to its rightful owners, which is traditional communities in the form of traditional councils. I think many people have looked at the persona in the form of traditional leader, and yet traditional leaders are leaders of traditional councils, which those councils are the authority that is respected by traditional communities, and of which those authorities are authorities that are responsible for allocating sites, for allocating developmental programs within those areas. So therefore, traditional leadership as an institution has a role to play in land ownership and land administration. So we cannot accept a notion that seeks to put the institution aside in terms of land administration. So as an institution, we support the motion to amend Section 25 of the Constitution to allow for the expropriation of land without compensation. However, such expropriation should not target the 13% of the land already occupied by traditional communities, because we believe that if you expropriate that land, you are expropriating it for who? Because you'd be taking it from African people that already own that land. We have a few categories of communal land, being trust land, land that has been allocated by the state, restitution land, and also land that has been bought by communities post 1994 that have bought those pieces of land privately. We're also proposing that expropriation should not be undertaken on that piece of land. I think as the sector, we hosted an indaba in 2017 under the theme of land ownership, tenure rights, and economic development. The declaration agreed upon by traditional leaders was, amongst others, first, a reversal of the legacy of apartheid that ensured the permanent loss of land by indigenous populations. B, government transferring the 13% of communal land to traditional authorities within 6-month period, and where there is no legislation, such legislation be enacted within 2 years for that to happen. Government also to undertake to have a land summit that is going to discuss the transformation of the 87% of the land parcel. So we are saying expropriation must cover the 87% of the land that is not in the hands of Africans. So we, as traditional leaders, we submit that it is necessary to amend Section 25 of the Constitution to specifically provide for the expropriation of the 87% of the land, so that our people can benefit from it, those that are in urban areas and those that are in rural areas. As the sector, we also took on a developmental role for traditional leaders. I'm sure some of you may have seen that we've just launched what we call an Invest Rural Master Plan by traditional leaders, of which we believe it is a blueprint for rural areas. We've adopted a developmental monarchs concept because we believe that the foundation of the economy in our country is not was never meant for us as the African masses. So we therefore need to re-engineer our economy as traditional leaders and traditional communities to make sure that our economy benefits our own people. And we're hoping that with this developmental approach, when land that is expropriated is returned back, it finds us ready with a master plan, and each and every traditional community having its own master plan on how to develop and use the land that would be transferred to it. Because I mean, we are always told that we cannot produce food, that expropriation will disturb will disturb the economy and all those. But if we do not plan properly now, we would have a problem when we receive the land. So we've already started as a sector. In terms of specific inputs on submission to Section 25, in terms of Section 25(1), it says no one may be deprived of property except in terms of law of general application, and no law may permit arbitrary deprivation of property. We are saying communal ownership of property must be protected through a secure tenure suitable to traditional communities. In terms of Section 25(2), we are saying public interest should include communal ownership and purposes. In terms of B, we submit that this clause must be removed from the Constitution. We do not support this, since dispossession was in the first instance without compensation. It was brutal, and our people died during centuries of dispossession. Reference to the history of dispossession. In terms of Section 25(3), on E, we are submitting that the entire section must be removed. Why should we pay for dispossession of stolen property? In terms of Section 25(4), we're saying this clause can remain but should be aligned. When it says that property is not limited to land, we support that. In terms of Section 25(5), we are submitting that the state has, for the past 23 years, not achieved much progress in this regard, and our submission is for the fast tracking or acceleration of fundamental change in this regard. We support Section 25, subsection 6, Section 25(7). We are making the insertion that says the 1913 cut-off date is not supported. There must be no date set as a cut-off. The arrival of the settlers and of trekkers was the commencement of dispossession. In terms of Section 25(8), we support that. Those are our submissions, Chair, as the National House of Traditional Leaders. Thank you. You are muted, Chair. You are muted, Chair.
Yes, I say there's a school of thought which says that people in communal lands should be given titles. What is your take on that?
Do you want me to answer that now, Chair, or wait for other questions?
No, you should wait for other people. I must take hands now. I have Honorable Shibambo, Honorable Mraseta, and we can proceed whilst others are still making up their minds. Honorable Shibambo.
No, thank you, Chair. I think we accept the submission that we must emphatically delete subsection 7 that speaks about 1915, at least from the National House of Traditional Leaders. Let's welcome that, and we should do exactly that when we finalize the other part and even the other components that are being dealt with there. But I want to check your view. So in November last year, the Department of Rural Development, Agriculture and Land Reform issued an advert that was basically saying it's an advert to lease state agricultural land. And that land, the land pieces which were issued there, it's part of the 13% which we are saying you must not touch. Already the state is in the process of auctioning that to those who want to perform agriculture in terms of what gets to happen. So I want your view in terms of that particular process, in terms of how do you then align it with your submission of saying that we must not touch the 13%? Because already that is under the custodianship of the state now, in the manner that it is, and will be auctioned to those who will possibly present whatever criteria that has been set by the department. Two is that the critique that we got about the role of traditional leaders in most of the public hearings, both in the Constitutional Review Committee process and the ad hoc committee process, is that traditional leaders do not give women land. They don't give land to females. In the majority of instances, they don't even allow females to inherit the land that used to be owned by their husband. So the custodianship of land by traditional leadership has always had those issues of gender disparities and discrimination in the manner that it is. But also you have got a situation where a lot of traditional leaders allocate the same piece of land to different people for different amounts and everything else. So there's no consistency in terms of how that is dealt with in land administration. Perhaps you must appraise us of what would be the best model of land administration, which must be democratic and much more equitable in terms of making sure that we all have got access to the land when the traditional leaders are given custodianship of parts of the land here in South Africa. Please respond to that. Yeah.
Thank you, Honorable Shibam. Honorable Mraseta.
Chairperson, thank you once again. Maybe it's true, let's welcome the presentation from the House of Traditional Leaders. And though I expected them to respond on one question which has been triggered time and again, can we be clarified, Chairperson, on this point that says the land that is already given to Black people should not be tampered with. You see, I'm saying so because it takes us back to the land given to churches. Whether the input as the presenter is putting it is not going to give space for an inquiry of some kind to establish if that distribution was done honestly and fairly. Because I'm saying so, Chairperson, understanding that there could have been other people who were weak and their land got dispossessed and be given to other powerful Black people, for whatever reasons. Are we going to leave it and say fair is foul and foul is fair? Because you see, what we do, we should not be seen as if, in as much as we are fighting dispossession, there are times when we will justify some other dispossession which were unjustifiably done. I thought the House of Traditional Leaders will come to the rescue of that situation, because like Honorable Shivambu is putting it, that women are apparently seen to be discriminated during their possession, land possession. So let it come very clear. Are they saying even where there were unfair practices, just be simply because the beneficiaries are blacks, so it must just be left like that? Thank you very much, Chair.
Thank you, Honorable Murat Setha. I think your question also relates to a point made earlier, whether there will be dispossession from black people who may also have acquired land through unfair means. So it's a very good observation. I don't see other hands. Does that mean that there are no other takers? I'll be flexible if people come back later, but in the meantime, let's allow Honorable Mahlangu to respond.
No, thank you, Honorable Chair. I will start with the questions that were posed by Honorable Murat Setha, especially maybe coupled with the one that was raised by Honorable Shivambu in relation to the views that the institution is not giving land to women. I would say that in most cases, when you have public hearings, Chair, I hope that you have noticed that there are funded views that are mainly expressed where people that are representing neoliberal structures would be presenting and coming up with that view, in some instances making reference to things that happened around 1960s or so, where apartheid was still at its prime and women were still treated like children. I think as a sector, we've really transformed. What we're not doing, we're not giving land to people that were not married. Whether you are a man or a woman, if you come alone, would not allocate a piece of land. But we've realized that in most cases, it is not a decision of women to get married, whether they get married or not. So, and women would have children at home and they would want to have their own space. And traditional leaders are allocating land to women. And we would want specific cases to be given, because we have women traditional leaders that are within the house. We have women that are participating in all structures of the institution of traditional leadership. And we've been moving very fast in terms of transformation. We've had quite a number of discussions as a sector on transforming the sector and making sure that women are empowered in rural areas in terms of land ownership. And that, so yes, there may be one or two instances, and we've always said that if an instance like that has been identified somewhere, can we be notified as houses, whether a local house or a provincial house, so that we can deal with that traditional leader, because he would be anti policy or agreements that the sector has agreed on. On the issue of land taken from one person to the other, I think in the main,
Are you still with us, Honorable Mahlangu? Honorable Mahlangu?
I think it's frozen, Chair, you can see.
It's frozen, eh? Are there any other hands in the meantime? Honorable Mahlangu? Honorable Mahlangu? I think whilst we are still trying to find you, we should proceed because time is not on our side. Advocate Bonani? Advocate Bonani?
Yes, Chair.
Are you able to help Honorable Masangu, or should we just proceed?
Maybe we should, I think it's a network issue on his side. Maybe we should proceed to the, okay, no, he's trying to rejoin us.
But we don't know how long it's going to take him.
No, he is back in.
Oh, is he back? Honorable Masangu?
I was disconnected, so I've tried to connect via my phone.
Okay, proceed.
Can I proceed? Yes, no, thank you. Yeah, so I've already responded to the issue of women, and there's an issue that was raised by Honorable Chivambo on the advert that has come out by the minister. We've already told the minister that we do not agree to that. We have been in discussions with the minister. I think the main reason that made traditional leaders to take a decision that land must be transferred back to traditional communities is that we don't own 13% anymore, because the Department of Rural Development has been giving those that own shopping centers and malls private title to the land. They've been giving private developers titles to land that is owned by traditional communities. Because once we give a permission to occupy, we still believe that the land is ours, but people will then go behind and work with the Department of Rural Development and allocate that land to monopoly capital, I should put it like that, because those shopping malls that are all in rural areas are now in private hands, and the land that they are on is also in private hands. And yet we've always been saying that communal land is not transferable, but the Department of Rural Development has been doing exactly that. So that's why we took a resolution that that land must be given back to traditional communities, and they must take their own decision on it. On the question that was raised by you, Chair, in terms of communal land, that it should not be titled, we are still saying that it should not be titled, because we are hoping that we should allow the most poor to have access to that land. And in most cases, when land is not necessarily titled, it gives an opportunity for a person that does not have anything to be able to be allocated a piece of land. Yes, there may be rogue elements within the institution of traditional leaders. So is in any other sector. And I think as an institution, we are prepared to deal with anyone that is not doing or not working according to customary law. We are happy that the TKLA, or Traditional and Cohesion Leadership Act, has been passed, because there's a lot of people that are claiming to be traditional leaders that are not, that keep on allocating sites in our areas, where a traditional leader will allocate sites and somebody else will then come and also allocate sites on the very same piece of land. So we'll be trying to deal with that element through the TKLA. In terms of issue of titles, we believe that once land has been given back to traditional leaders, I think together with their own communities, can decide on the form of tenure system that they want to enter into. We were even proposing that maybe the permissions to occupy that we are giving to our own communities, I think those should be strengthened. Maybe they are not strong enough to secure the person that has been given that piece of land, because I think a lot of people have been saying that they are afraid that a traditional leader might wake up tomorrow and remove them from the land that they've been given to. So we are prepared to discuss a tenure model that will secure the right of those people that have been given land, but not necessarily opting for the issue of title, because I think the issue of title deeds has been used as a panacea to all the problems that we have in the country. And we are saying title deeds are not the only answer.
to the land problems that we're experiencing. So we would move a bit slow in terms of title deeds. I think we'd rather have our people being capacitated, being trained on the meaning and valuing the land that they own, because we also have a system that has destroyed our understanding of the value of land. That's why people will just not work the land, leave the land lying fallow and not appreciate the value of that land. So we are hoping that the capacitation program would assist us. And I think in our Invest Rural Master Plan, we are dealing with that issue of trying to make our people understand the value of the land.
Thank you very much, Honorable Masangu. Can we then move on to the Land and Accountability Group? Land and Accountability Group, Advocate Ramano, are they here?
Yes, Chairperson.
Hi. Yes, yes, we're here.
Yes, proceed.
Thank you. Good afternoon, honorable members. I would like to thank you for the opportunity to address you today on this very important issue. I am Zinanda Boy, the lead land researcher at the Land and Accountability Research Center based at UCT. The Land and Accountability Research Center uses research, advocacy, and litigation, as well as partnerships and collaborations with stakeholders, with the aim of achieving recognition and protection of rights in the former homeland areas. Throughout our work, we see daily illustrated the dire need for substantive progress in land reform efforts, the need for progress in the achievement of land reform to address continued injustices and relieve the desperation for land and security experienced by a majority of South Africans cannot be overstated. Unfortunately, as the preamble of the amendment bill states, it is still the case that a majority of South Africans who bore the brunt of injustice and indignity of arbitrary land dispossession during colonialism and apartheid continue to be palpably hungry for land 27 years into our democratic dispensation. The amendment bill we are considering today aims to make explicit that which is implicit in the Constitution, so that an amount of nil compensation is explicitly stated as a legitimate option for land reform purposes. In the context of the aim of the amendment bill, I will be dealing with a single broad issue, which we went into a lot of detail in our written submission. That the requirement with the insertion of subsection 3A in section 25 of the Constitution, that the national legislation must set out specific circumstances in which a court may determine that compensation that is payable may be nil, is likely to be an unconstitutional limitation of the power that the state has in terms of section 25, as it now stands, to constitutionally expropriate land for the purposes of land reform. As the Constitution now stands, section 25(2)(b) provides that expropriation that is done in terms of a law of general application for public use or in the public interest should be subject to compensation that is agreed to by the affected parties or decided or approved by a court of law. The amendment bill seeks to insert an additional proviso in section 25(b). This stipulation, which is articulated in the intended subsection 3A, provides that compensation can be determined to be nil where expropriation is for the purposes of land reform. However, this newly inserted subsection 3A goes further than just explicitly stating that compensation can be determined and confirmed as nil. In setting the constitutional parameters of expropriation with nil compensation, subsection 3A requires that national legislation must set out specific circumstances in which it may be determined that nil compensation is appropriate. Through the use of the phrase specific circumstances, the ambit of the state's power to expropriate with no compensation for the purposes of land reform is seriously limited by the Constitution itself. Also, it is also a limitation on the court's ability to exercise its constitutional function of adjudicating the provisions of the Constitution and carrying out the balancing act between the public interest and the interests of those affected by using the non-exhaustive clause in the non-exhaustive list in subsection 3 of section 25. This is an important function of a court that is effectively done away by this provision. Before the Joint Constitutional Review Committee, it was our submission that a proper reading of Section 25 of the Constitution already allows for expropriation with no compensation for the purposes of land reform in a manner that is set out in legislation. We emphasized that one of the most important functions of Section 25 is empowering the state to take action to promote land and related reforms that are aimed at reversing the injustices of our past. The Bill of Rights, as well as the Constitution, aims to empower the state to enable it to achieve a society based on social justice and fundamental human rights. In South Africa's context, it is an important aspect of achieving that is ensuring that the state is sufficiently empowered to legitimately make significant interventions in South Africa's existing distribution of wealth and property. Land dispossession was at the center of the injustices and indignities imposed on a majority of South Africans. Achieving land reform is a fundamental aspect of beginning to create the society envisioned by our Constitution. It is therefore important to ensure that the state has full access to the powers given to it by our Constitution, which are necessary to achieve a society that recognizes and seeks to remedy the injustices of the past to ensure a brighter and dignified future for every South African. But this current attempt at making explicit that which is implicit in the Constitution could severely curtail an important tool the Constitution already makes available to the state to achieve land reform. It is our contention that subsection 3A would be an unconstitutional limitation of the power of the state to take necessary and constitutional steps to achieve land reform. As mentioned before, the phrase specific circumstances, when referring to when compensation can amount to nil, constitutes an internal limitation of the rights and powers in Section 25 as they relate to achieving land reform with the use of the state's constitutional expropriation powers. This phrase, which seems to require an exhaustive list of circumstances in which the state can use its power to expropriate with no compensation, unreasonably limits the mechanisms available to the state to effectively achieve land reform. Section 25(1) and other provisions in the Constitution already provide sufficient limitation to the state's power to expropriate. Section 25(1) provides a negative procedural right not to be arbitrarily deprived of property. The rest of Section 25 articulates procedures and positive rights that allow for constitutionally compliant deprivation of property through, amongst other things, requiring a law of general application and a balancing of rights and interests. Before the current expropriation bill being considered by Parliament, no previous attempt had been made to articulate the state's post-apartheid powers of expropriation. The extent of the state's powers in terms of the Constitution, which we contend already includes the power to expropriate land with no compensation, has never been articulated or tested. It is inappropriate to limit this power with an internal limitation as is proposed by the amendment bill as it stands. The Constitutional Court has made it clear that when giving content to constitutional rights and principles, as well as the powers of the state to give effect to those rights, a purposive and generous approach must be used to ensure that the aims of our constitutional project are achieved. When the state gives effect to a right in terms of legislation, it is able to legitimately limit that right through a law of general application in terms of Section 36 of the Constitution. Section 36 is applicable to Section 35, and thus an internal limitation in Section 25 is not necessary. Any limitation of the powers of the state to expropriate is better suited to being articulated in legislation, the reasonableness of which will be tested against Section 25 as well as Section 36 of the Constitution. Placing the limitation in the text of Section 25 will prevent the testing of the ambit of this power and the development of rich jurisprudence relating to what just and equitable compensation looks like in varying contexts, including when no compensation would be just and equitable. Starting from a narrow position in giving content to constitutional rights and powers when the objective is to give effect to those constitutional rights is not a good idea. It eliminates the opportunity for enabling legislation to use the full extent of state power currently available in terms of the Constitution. Put differently, a narrow empowering provision in the Constitution results in limited and restricted enabling legislation, less likely to serve the objects, spirits, and purpose of the Constitution. All the Constitution needs to do is require that national legislation be passed that would not legalize arbitrary deprivation of property and that does not violate Section 36. The Constitution already does this. What that legislation will look like needs to be left to Parliament to decide. If it decides that legislating a closed list of instances where expropriation with no compensation is allowed, then Parliament can do that, as it has done with the current expropriation bill, which is being drafted and passed in terms of Section 25 as it currently stands. Leaving Section 25 as it is allows the legitimacy of Parliament's decisions in that expropriation bill to be tested against the standard of an appropriately empowering Section 25, as well as the standard of just and equitable compensation, including the non-exhaustive factors listed in Section 25(3) and the reasonableness of those provisions in terms of Section 36 of the Constitution. The intended subsection 3A, as it stands, will, with this internal limitation, would prevent any substantive inquiry into the reasonableness of compensation, of no compensation in circumstances that are not part of the closed list. Doing so takes away opportunities to explore and develop what is constitutionally permissible. I'm happy to answer any questions from the honorable members, and I thank you again for the opportunity to address you.
Thank you very much for a brilliant analysis of the Constitution. Any hands? I don't, Honorable Shivambo. Honorable Shivambo.
Chair, I don't hear what she's saying. I honestly did not hear. I don't know what is being, but what she's saying, they must amend the Constitution or must leave it as it is. Let's ask for a specific input so that we're able to engage in terms of this thing. Are you saying we must amend the Constitution to permit for expropriation of land without compensation? What is your view about the subsection 7 of the Constitution in section 25 that says that the cut-off date must be the 19th of June 1913? What is your submission? I can't hear you. Maybe.
Oh, I'm sorry. So the submission I was making was based off of the fact that a decision seems to have already been made that the Constitution is going to be amended. What the submission is saying is, reading the text of the proposed bill, that the phrase in the text that says that national legislation that will be passed to give effect to the power of the state to expropriate with no compensation needs to be articulated in national legislation by giving specific circumstances under which no compensation can be used. What I'm saying and what we're saying is that the phrase specific circumstances in that provision limits the ability of Parliament as well as the courts to operate, because if the Constitution itself requires specific circumstances to be articulated for there to be legitimate use of that power, then that limits the ability of Parliament, for example, to sort of give us more than what the Constitution says. Right now, the Constitution is quite broad and it's quite empowering in how it articulates the power of the state to expropriate. But then requiring law to say which specific circumstances no compensation is okay will limit that power, because that limitation is not going to be in legislation that can be amended. That power is going to be, that limitation essentially is going to be in the Constitution itself. So we're then going to be in a situation where we're starting from a provision in the Constitution that is incredibly narrow, or narrower than it is right now. And then because that provision in the Constitution is narrower than it is right now, then the resulting legislation or legislation that then will be passed by Parliament can't do more than the Constitution allows. So then what we're saying is that if we're going to then be amending the Constitution, what needs to be said is legislation can be passed to give effect to the powers of Parliament of the state to expropriate with no compensation. But then the Constitution itself shouldn't require specific circumstances to be given. It should leave that legislative power open, and Parliament can then do what they think it needs to be done. And then whenever Parliament acts, when we're testing whether or not that legislation that Parliament is passing is constitutional, we're using a much wider wording of the Constitution than a narrow wording that says what Parliament needs to do is to pass specific instances that says those instances are the instances in which expropriation with no compensation is appropriate. I don't know if I was clear there.
Honorable Shivambo, have you had her now?
I think I require translation services. I'll ask Sinawo to translate for me later on. I still don't understand.
Okay, no, fine. I told you that 100 lawyers can give you a different 100 interpretations. So don't worry. I understand your challenge. Honorable members, any other questions? There are no other questions. Can we move to Honorable, I didn't catch this, Advocate Bonani?
It is Ndifunukwazi.
All right, thank you very much.
On Mfunagwazi. Ndifuna Gwazi. Yeah, let them take the floor. And thank you, Mama Zande Boy. Thank you very much for your input. Ndifuna Gwazi, the floor is yours.
Hi.
Hello?
Good afternoon. Yes. Am I audible?
You are audible, but I can't see you.
My camera is on. Let me just check. Apologies. I'm not sure why I'm not showing.
No, it's fine. It's just that you are showing now. Proceed.
Am I showing now? Okay, great. Yeah. Good afternoon, honorable members. I am Mandisa Shandu, and I'm the director and an attorney at Ndifunugwazi, which is an activist organization and law center that combines litigation, research, and advocacy, as well as community organizing in campaigns that are targeted at advancing urban land justice. And so our interest is particularly on how land can be made available on an equitable basis, with an interest on access to affordable housing as a tool to disrupt spatial inequality, but most importantly, to disrupt the reproduction of the apartheid city. I'd like to thank the ad hoc committee for the opportunity to make written submissions, as well as this opportunity to make an oral submission on these really, I think, important legislative reform processes. In my submission, which I hope to keep brief, I would like to make some broad remarks about Ndifunugwazi's position on the proposed bill, as well as make two very discrete points. The first point is around the central oversight function for the courts in determinations about the payment, if any, of compensation during expropriation, as well as the centrality of national legislation to specify the circumstances under which a court may determine that no compensation should be paid. Moving on to our position, first, I think it's important to state that Ndifunugwazi, given our broad goals of advancing urban land justice in an increasingly unequal society, is Ndifunugwazi supportive of the use of expropriation with or without compensation as a means of achieving land reform and combating spatial inequality and the related inequalities, including obviously racial as well as spatial. We understand that expropriation, if properly utilized, could definitely contribute to being one of the variety of tools that can be used to broaden access to land, especially land which is out of reach, which would include well-located urban land, to people who are currently excluded from land markets. This would entail, in the urban context, particularly the poor and working class residents in our cities. However, and notwithstanding our broad support of expropriation, when considered in the context of South Africa's greater land reform project, we remain concerned that the current debate about the proposed constitutional amendment to give effect to expropriation without compensation is potentially distractive and also misplaced. We'd say distractive because it does not address primarily the real barriers to achieving urban land reform, particularly in urban areas, an aspect that has not featured dominantly in the post-apartheid discourse on land reform. These barriers include, for example, institutional capacity, budgetary constraints, corruption, as well as, I think, a highly exclusive and exclusionary land market where land is first and foremost treated as a commodity as opposed to something that could leverage a serious societal reform. And I think that what this exposes is an inability to really challenge the underlying property system and revisit holistically what it is that enables or ensures rather that inequality and inaccess to land is the status quo. And the secondary concern, a broad concern, is around this process potentially being misplaced, in that, as other presenters have mentioned today, the government has always had the powers to expropriate land within the parameters of the Constitution. As members are aware, the Constitutional Property Clause, particularly sections 25.5 through to section 25.9, provide the basis for progressive land reforms. And so the Constitution is, in its current state, self-aware of the need for land to be central to achieving any form of redress and also, I guess, future redistribution of land. And so the concern here is that the state's power, just to step back. So among the various constitutionally mandated measures, the Constitution allows for expropriation of land through a law of general application as a key policy tool for land reform. Moreover, the state's power to expropriate is not dependent on the willingness of the landowner. Basically challenging this principle of willing buyer, willing seller does not appear in the text of the Constitution, but is a self-imposed policy restriction of previous governments. So although the Constitution provides that the expropriation of land must take place against the just and equitable compensation, it's entirely possible that the factors listed in section 25.3 may mean just an equitable compensation. That could mean that that would be below the market value or as little as R1. And so the premise or the understanding that I think the bill is proposing, that the Constitution ought to be amended to give effect to this, we stand with previous submissions that actually is not necessarily the case. In addition to the Constitution, there are existing laws that already permit what is trying to I think be achieved through this amendment. For example, the power to expressly and implicitly do this is provided for in a range of redistributive laws, including the Housing Act, section 9.3 of which provides that a municipality may expropriate any land for housing development if it's unable to purchase the land through an agreement with the owner, as well as the Land Reform Tenants Act, the LTA, which also enables the state to expropriate land to give effect to the land rights of labor tenants. And so I think what this poses is a serious question about if there are parameters within the constitutional framework to do this. Perhaps the other aspects that are informing, I guess, a very slow, if at all, rate of land distribution. The focus rather needs to be to look at the barriers in place. But nevertheless, because we are aligned with the broad principle of expropriation as a tool for land reform, and the acceleration of which is critical given the context which many other speakers have already described, I just want to touch on those two discrete points which I mentioned about the current formatting or draft. The first is around the role of the courts. So the current language of the bill reserves an oversight role for the courts. However, throughout this process, there have been some comments about limiting the role of the courts in determining the amount of compensation in cases for purposes of land reform. In particular, there have been submissions that the role of the court should be limited to administrative review when it came to expropriating land and property in the public interest. Specifically, a comment that was concerning was that stated that the power to determine issues related to expropriation of land compensation should reside with the executive. Furthermore, in December 2019, this in an ad hoc committee of in a meeting of this ad hoc committee, there were suggestions that limiting the court's oversight role to the ability of review decisions about compensation would actually speed up the land reform process. We take issue with this argument, which implies that the court's oversight function would be time-consuming, bureaucratic, and likely to delay the process. And perhaps it's worth interrogating if this actually would be true. Our submission has been that the court oversight role is essential, and that it would be deeply problematic to give any member of the executive the primary oversight function in relation to determining which circumstances for expropriation could be null. There are two primary reasons for this. The first is that land reform and spatial transformation cannot be seen purely as a political project that could be subject to the priorities and or policies of the government of the day. It's a long-term project, land reform is, that is likely to extend over multiple successive governments. And so the courts, as an independent and impartial branch of government, are therefore ideally suited for furthering a long-term land reform project. And so the concern there is really to emphasize the importance of the centrality of the court in making determinations about the compensation to be paid, if any. And related to this I'll move on to our second discrete point, which is about the enabling legislation, an issue which has also been touched on by previous speakers. So I guess as the last speaker, I do have the benefit of flying through this, but I guess a primary concern here is a concern about potentially putting the cart before the horse, a type of approach that overemphasizes this process of amending the Constitution when, or actually while, or actually even before enabling legislation, which is more suited and appropriate to deal with the nuances that would ultimately give effect to the goal of land reform is underway. The concern here is that the state, during this process, didn't release the national legislation as well as guidelines at the time that would, I think, given more comprehensive and informed comments of exactly how this expropriation as a mechanism would operate. Of course, over time, this has shifted with the expropriation bill now being considered, the one led by the Public Works Department. But I think it's really important to just emphasize that the Constitution in of itself would provide an abstract legal framework, which ought to be refined by national legislation. And so I think it's an appreciation of that. An amendment here, I agree with previous submissions, would be potentially restrictive, but also the national legislation is really where I think we will be able to see the potential for accelerated land reform. I will end my submissions there, but maybe just to strongly recommend the speedy enactment of this national legislation to specify the circumstances under which the courts may determine the amount of compensation payable in an expropriation bill, as well as really giving effect to, I guess, a list of what would principles or a list of that would guide what is just and equitable compensation.
Thank you very much for your eloquent presentation. I will now take hands from the honorable members who wants clarity on your presentation. Honorable Mahlatsi.
Thank you very much, Chair. Good afternoon, Meshandu. Thank you very much for your explicit presentation. I've got 3 questions, Chair. Firstly is, I want to check with Meshandu that what is her understanding of this particular process that we are undertaking now? This question is informed by her input that this process is misinformed based on the needs of the country. If I got her, I understood what she was saying, because my view is that why would we take such a tedious process as Parliament if indeed it was misplaced or misinformed? Number 2, Chair, is on the financial capacity constraints. She indicated in her, I think in her first paragraph of her presentation that the process of expropriating land without compensation will have financial and capacity constraints. Now, my question is, if this legislation goes through, clearly we're indicating that there will be expropriation of land without compensation. What will be the financial constraints in that regard? Because in my view, Chair, why would there be financial constraint if there's no compensation that is going to take place? Two, the reason why we are embarking on this process is because the willing buyer, willing seller has not worked. There's been massive inflation of the market value in terms of property and land. That is why there is a need for this particular process to actually ensure that our people have land. On capacity constraints, I think Meshandu has been following the discussions and during the presentation that have been made prior to hers, that we have indicated that capacity, in as far as the process is concerned, has always been due to elements of restitution, not necessarily redistribution. So in terms of capacity constraint, what exactly is she referring to? Lastly, Chair, is on the courts. I think also Meshandu has been following the debates today, and she would have understood or most probably heard that there is a difference between the legislative process and the judiciary. Now, why would she think that the courts must be the determining factor in as far as this particular process is concerned? Because when people voted for a particular government, they were putting their interest, their financial and economic and socio-economic issues at heart first, and they voted for a particular government. Now, why would now we take this particular process away from their public representative and take it to the courts? And lastly, Chair, does she really think that our judiciary is transformed to a point whereby it can deal with this matter? Thank you, Chair.
Thank you, Honorable Mahlatsi. Any other question? There are no other questions. Mesh Shandu, can you respond?
Chair.
Yes. Oh, yes, Honorable Shibambo. Yeah, proceed.
Yes, Ndufunukwazi from the group. Who are they? Where do they come from? Who funds them? And what do they stand for? And who are the board members except the one who are speaking here? I think some of the things will be able to understand in context. Like
Honorable Shandu, you know, other presenters actually gave us the background of who they are, how they constituted, what are the objectives. So I think Honorable Shibambo's question is fair. Do you want to help us there?
Sure, not a problem. If I may answer that first before I go into Honorable Mahlatsi's questions, is that okay? My apologies for not going into too much detail here. I took that for granted given the detail given in our written submission. However, I can say that Mfunuwazi, as mentioned, is an activist organization and law center based in Cape Town that uses litigation, research, advocacy, as well as community organizing and campaigns that are targeted at advancing urban land justice. Our mission primarily is to see the well-located parcels of land unlocked for the purposes of housing, which is our socioeconomic interest, as something that we see as critical towards disrupting the reproduction of the apartheid city. And what we mean by this is really challenging the continuing spatial inequality that is evident across South African cities, but particularly, I think, highly visible in Cape Town, where we are located. In terms of who we are funded by, we are funded by a combination of local as well as international donors, and we also do receive some funding from some smaller contributions from individuals who have an interest in supporting this kind of work. In terms of our board members, I don't know if you are specifically asking for a list, but our written submission has on our letterhead the board members that are in Lifungwazi.
Thank you.
The names of the funders.
I beg your pardon?
Funders of the organization, what are their names?
Well, would you like me to list?
Yeah.
Okay, can you give me a second for a comprehensive list? Okay, let me go from the top of my head. Locally, we are funded by the Constitutionalism Fund, as well as the Wraith Foundation and the Claude Leon Foundation, and as well as Open Society South Africa. We are also funded by the Ford Foundation and the Bertha Foundation and Comic Relief, as well as the Cameron Shear Foundation.
Honorable Shibambo, can we leave it there?
No, it makes sense. It makes sense, Chair. No, it's okay.
Yeah. Okay. Thanks. Do you want to address the questions raised by Honorable Mahlatsi?
Yes, please. Thank you, Honorable Mahlatsi, for the detailed questions and for engaging with some of the issues that we brought forward. First, in relation to the question about this process, no, it's not my submission that this process is misinformed. As I stated, our overarching position is that we are supportive of the need to use expropriation as a tool to advance, accelerate land reform. The point that I'd made rather was it being misplaced, in the sense that the Constitution, and I align myself with the previous speaker here, already provides the basis for expropriation as a tool, and it is possible within the current parameters of the Constitution that this might mean nil or even compensation of as little as R1 if the circumstances would require it so, and those circumstances would be whether it would be just and equitable to do so. I envision, for instance, if there were a land occupation where people who are absolutely landless and have no choice of any other access to securing a home, if that land were to be expropriated, say for instance from a private property owner who has no interest in that land, it had been underutilized, it had been vacant, and the circumstances would allow then for an expropriation of that land to then build on services, etc. That might be a situation where it would be just and equitable under the current constitutional framework to give nil or very little compensation. So that is what the overall point was about. The current parameters of the Constitution potentially do allow for accelerated land reform, which at the heart of it would contribute to addressing various issues, including landlessness, tenure security, and various forms of inequality. The second question was around financial constraints. The point that I was making there was not to say that this would be an overly financially burdensome process, not at all. But I think that what's important is to look at the current financial constraints that limit the ability for rapid and accelerated land reform. And I do support that this is something that is desperately needed. And in fact would require more financial resources to activate. The point about the willing buyer and willing seller, I guess this is related to my initial point that this was a policy position from previous governments and not necessarily one that is established in law, in any law, as a position that would or should limit the ability to expropriate for little or no compensation. And so if the idea is that we want to move away from willing buyer, willing seller, this is a policy position. And so is it appropriate to rather amend the Constitution so that the policy position isn't dominant? I don't think so. And finally, the questions around the courts. I think this is something that was similarly addressed by Kasek, who spoke earlier, around the question of separation of powers. Perhaps if I take a step back, I think that an ideal scenario, given how very heated the position is in all aspects, from executive, legislative, as well as the judiciary function. I think that a process that might provide for more transparency and, importantly, I think legitimacy, as I stated, we broadly support the need for expropriation. And so legitimizing this through objective legislation, which is the national legislation, we refer to the current draft bill, which sets out the criteria for just and equitable circumstances. And then for that to be determined by a court is something that actually is better aligned, I believe, with the principle of the separation of powers, and something that would not necessarily then be at the whim of whichever political party is in position at the day. And I say that really appreciating that the Parliament has currently taken this, I think, as far forward as the land question has been taken far forward since at least 2018, when this was currently being debated. And so it's not to negate the work, but rather to think about how to sustain in a long-term kind of fashion that's beyond the cycle of a political party. And the suggestion is to
let's leave it there.
Okay, through national legislation and determined by the courts.
Thank you very much, Ms. Shandu. Advocate Ramano, it's legal resources. Are they there? Legal resources. Advocate Ramano. Advocate Gwebu.
The legal. Okay.
Yes.
Yes, the legal resources is next. Check. Let me just check if they are around. But I don't think they are here. Let me just confirm.
Okay. Are you still confirming?
Chair, they are not yet on the platform. Maybe we will have to do away with them. They are not here.
Okay, they've done away with themselves, not us doing away with them. Yeah. Who is that?
Is Matlati, Chair.
Yes.
I was going to propose, can't we take 5 to 10 minutes break while they look for legal services?
Excuse me, Chair. I am here, Pauline Wickham from the Legal Resources Centre. Apologies.
Are you there?
I am here. Yes. Apologies.
Yeah. Introduce yourself and proceed. And thank you for your attendance.
Thank you. I apologize. My camera is not working. I'm not sure why. But thank you very much for the opportunity. The Legal Resources Centre is an independent, non-profit public interest law firm, a law clinic established in 1979, and it uses the law as an instrument of justice. It works for the development of a fully democratic South Africa based on the principles of substantive equality, for providing free legal services for the vulnerable, marginalized, including the poor, homeless, and landless people and communities of South Africa. The LRC represents and has done for a long time citizens and communities in litigation involving restitution, including in particular restitution for labor tenants, customary law and the status of customary property rights, communal land and new developments on communal land, redistribution and housing. And some of the cases you may have heard of, the Richtersveld case, which was the first one where customary land ownership and customary ownership of minerals were recognized. La Mosa case about restitution, where lastly around labor tenants, etc. But I want to specifically mention two cases that the LRC has been involved in and that I think are very relevant to the hearings here, and some have been mentioned. And I think it speaks to the problem that the committee is trying to solve here, or is mandated to solve. The first case I want to mention is the Florence case. And this was a case that we brought on behalf of a family that was dispossessed about 80 years ago well, even before apartheid. And the case was about what compensation would be just and equitable to be paid to people who are dispossessed. And the reason we brought this case is because what our courts have been doing and continue to do is when they calculate compensation for dispossessed people, they take the amount of the property 80 years ago and they use the lowest possible escalation index to determine the value today, namely the CPI or consumer price index. And so the result of that is that dispossessed people are still getting far below, let's call it market value, as just and equitable compensation when getting restitution through our Restitution Act. And indeed, the Florence case, where we try to change that and try to establish a principle that dispossessed people, more than anyone, should get something closer to market value in compensation, we ultimately lost that case. On the other hand, a case, the Masiza case, and it was actually mentioned by the representative from the BLS earlier. The LRC represented Mr. Masiza he was a labor tenant, and the case was about the compensation to the landowner. And this was the case in which then acting judge Ngugai Tobi in the Land Claims Court found that the compensation to the landowners could be below market value. And we brought that case to start to establish where the Constitution allows for compensation that is, below market value and even nil. And indeed, as was mentioned, that case was overturned by the Supreme Court of Appeal. So in both cases, our clients ultimately lost. We don't think that it's because the Constitution does not allow for compensation, expropriation without compensation. We do think that it says a lot about the legal culture of our courts and litigators in South Africa. And this continued reverence for common law ownership as the gold standard that should always be compensated with market value, and other forms of ownership and dispossessed people not being entitled to the same standards of compensation. So for that reason, we think what this committee is trying to do, which is make explicit that expropriation with no compensation is allowed in terms of the Constitution, is important. The courts need this guidance. It is clear to us. And so for that reason, we support it. Now, the question is, will this amendment, will it make things cheaper and faster, and therefore speed up land reform that we all want to see? Well, we want to make the following two proposals for how this committee proposes to amend the Constitution. The first is that we don't think that the courts should be the only one to decide when expropriation is no compensation. It should be also an administrative decision. If it can only be the court, then that will make things very, very slow. So there have been questions about the court's role from previous speakers. Judicial review will always be a constitutional right. The Constitution provides for that in other sections. And so any administrative decision can be reviewed by court, but it should not be the courts who are the only ones who can determine expropriation without compensation. And so we recommend that the references to the court in clauses 1A of the amendment, that those be removed. Secondly, we also think that if you want to avoid being tied up in courts endlessly, which makes things more expensive and slower, then there should be greater clarity as to when expropriation with no compensation is appropriate, But as our previous speakers, we also agree that that should not happen in the Constitution. That should happen in legislation. But this constitutional amendment can explicitly mention that there will be factors to be taken into account and that those will be fleshed out in legislation. And that will hopefully ensure that we don't ask the courts to make all of this stuff up from the start. It's expensive, it takes long, and the courts are not the most progressive place for that to happen. Questions: will this amendment reverse ownership patterns? Will it resolve restitution backlogs? Will it ensure equitable access to land and further empower the majority of South Africans to be productive participants in ownership and food security and agricultural reform, as the preamble states? On its own, no. And I will not repeat what many people have told this committee. This amendment is important, but it is only one tiny part of a bigger change that is required in capacitating the Restitution Committee, in adopting a legislative framework for redistribution to make sure it goes to the poor and landless, and proper post-settlement support, etc. So this is not going to solve everything, but it is important. Finally, I want to raise what for us is a major concern, and that is to say that this debate around expropriation without compensation, and even expropriation by itself, it mostly centers around the common law ownership of white people and their concerns. Whereas in reality, every day, Black communities are being deprived of their land rights. Most mining and big infrastructure development is happening on the land of Black communities in South Africa. Very often, their land is not even being expropriated. It is just being deprived, and they are never given anything near market value compensation. And that, we think, is the real concern and is kind of a blind spot of this process. So our courts, to their credit, have gone a long way in recognizing customary property rights as ownership rights, as strong rights equal to any common law right. And yet we still see the executive struggling to recognize people's customary property rights. We also represent the Kolobeni community, who is the one community in South Africa that have stood up and said, we do not want our land to be taken for mining. And they were successful in asserting the right to say no on their land. But the Minister of Minerals and Energy is appealing the decision. And this is our concern, that in cases like that, communities are not getting nearly the same protection that common law owners are getting, and not even to mention the possibility of market value. And that should really be where the debate is. But how to protect those communities, that is an issue, I think, for legislation. And finally, to mention that the chair said earlier that we need African jurisprudence on land, and we couldn't agree more. And the African Charter on Human and People's Rights have gone a long way in recognizing people's rights, which is nowhere recognized nowhere else in the world, people's right to development, communities' rights to development, and the customary land rights. And there's important African jurisprudence around that. And that's what we should be infusing our law with to change this legal culture that is stuck in old school colonial notions of common law property as the gold standard. We thank you for the opportunity to make an input.
Ms. Wickham, how do you spell your surname, pronounce your surname?
Wickham is correct. Wickham is correct. W-I-C-O-M-B, it's correct.
Thank you very much for your insightful contribution. Would you mind, I can see that you are actually a practitioner, you have empirical evidence on the things that you are talking about. If you could submit something on your presentation, because the time we allocated today is short, but if you can just elaborate and send that to the committee secretaries, Advocate Ravano and Advocate Gwebo. We'll appreciate that.
Thank you very much. I'll do so.
Okay, thanks. Honorable members, any questions for clarity? I think we have done a good job. Honorable members are happy with the presentation, so we will release you. And honorable members, that brings us to the end of the session, and the meeting will now adjourn. Thank you very much.
Thank you, Chair.
Thank you, Chair.
Long live honorable members.
Long live Chairperson.